Good morning. This is Jason Montoya with the PRC. Today is December 2nd. It's approximately 9:15 a.m. and I'm sending a message to test YouTube. Thank you. Good morning, Mr. Chairman. Can you hear me? I think you're still muted. Maybe on your, let me see here.
There we go.
There we
A few minutes ago, I sent out a final edited copy of the policy paper at the end of the agenda.
Okay.
And that's something I'd like you to put up on the screen when we get to that part of the agenda.
Yes, sir. I have it here before me. Thank you. No problem.
When it comes up, it tends to come up with all the edits showing, and you just have to go to the,
Yeah.
I sent a little follow-up of how to get to the clean.
I'll definitely show the clean copy.
Yep.
Yes, sir.
I can't figure out how to print the clean copy.
Well, I think I can send you a clean copy and then you just print it.
No, I've got it on my, I've got it on my computer. No need
Okay.
to do it.
Okay, fair enough.
And Hans, whoops, he probably can't hear me.
Yeah, he should be able to hear you, Chairman. He can hear you.
Hans?
Yes, I can hear you, Commissioner.
Oh, okay, great. So I just saw we got that order, or we got that recommendation from transportation.
Yes, I will not be addressing that during my presentation, Mr. Chairman. As you're probably aware, that was actually, since that was filed after publication of the agenda,
Right.
I do not want to address the specific relief in that. So I will be proceeding off of my proposed order, which brings it before the commission on its own accord from this office.
Okay. And John? Well, I guess actually, Jason, this is your territory. Is there anything you're planning to do with that?
Well, I typically defer to the commission to call on staff for any input. I think I just need to make a couple of points on the reason for it, if the commission would like to hear.
Okay.
Jason, did you get my text?
I also want to recognize, good morning, Commissioner Espinoza. I think we have you on the phone now. Commissioner Vicente Aguilar seems to join us. Good morning.
Good morning, Jason.
Good morning, Commissioner.
Good morning.
Good morning, Chief.
Good morning, Commissioner Byrd. How are you, sir?
Good morning.
I'm good. How are you
Number
guys?
2.
Good morning.
Good morning, Commissioner Hall.
Good morning.
I believe we have all the commissioners on board. Valerie, you're there?
He is, Chair. I do see her phone number there.
Okay, we're ready to go. And we'll start with the pledge. I see Chris. Ryan, I see you on here. Can you hear me, Chris?
I can hear you, Commissioner. Can you hear me?
Yeah, I sure can. I figure I'd have you do the pledge since you've got a big item on the agenda today.
Sure.
That's your punishment.
Very good. Okay, I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, undivided, with liberty and justice for all.
And New Mexico? Or you're not familiar with that?
I'm not terribly familiar with it, but I can pull it up on Google.
No, I'll have Commissioner Hall do New Mexico.
I salute the flag of the state of New Mexico, the Zia symbol of perfect friendship among united cultures.
Thank you very much.
Well,
Introduction of special guests.
I don't have any, Mr. Chairman. This is Jason.
Okay, terrific. Public comment.
Yes, Mr. Chairman, we have several individuals that have signed up to give public comment today, primarily.
Excuse me, Chief of Staff.
Point of order.
I believe we skipped 2 items, consideration and approval of the agenda, which is listed the second item on the agenda.
Yeah, thank you. Thank you for pointing that out. Consideration and approval of the agenda.
so moved.
Second.
Please take the roll.
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Espinoza, Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman.
Aye.
Going back, is Commissioner Espinoza present?
She is present. Let me see if I can get her unmuted, Mike, if needed.
In any event, the agenda would be approved by a vote of 4-0. If you want to go back, we can, but otherwise we could proceed.
I think we're good here. Valerie will be on in a couple of minutes. And by the way, before we go to public comment, I should just wanted to say, I hope everyone had a great Thanksgiving holiday. So
Thank you, Mr. Chair.
now let's go on to public comment.
Thank you, Mr. Chairman. And thank you, Commissioner Vicente Aguilar, for correcting me in that order. I do have several individuals that have signed up to give public comment and have gotten confirmation from the Office of General Counsel that neither of them are a party to the case that they want to give comment on. It looks like all of them are discussing the topic related to the Newman Generating Station 19-00349-UT. And so, Mr. Chairman, I would just go in the order of the sign-up sheet given to me from the General Counsel and call on Kyle Fiore. And I apologize if I mispronounced the last name, and I see Kyle here. There you go.
You did a pretty good job of good pronunciation. Thank you. And thank you for recognizing me. My comments today regard the establishment of the Newman Generating Plant in Chaparral. I speak in opposition to the establishment of the plant. Chaparral is a high desert community. The last census shows approximately 31% of the population of Chaparral living below the poverty line. This statistic includes 42.6% of children under the age of 18, making the number today still exceedingly high. For a child, growing up in Chaparral is already hazardous. Buffeted by frequent sandstorms, the Chaparral air also has an exceedingly high ozone count. The establishment of the Newman plant would add nitrous oxides, volatile organic compounds, carbon monoxide, and carbon dioxide to this already hazardous air. daily affecting the development of children's lungs and exacerbating the development of diseases such as asthma. Little's been said about the physical effect of the Newman plant on the future generations of chaparral. Community voices, those of mothers, fathers, and young people themselves, have not been included in the approval process for the plant. Local voices must have a determining say in the development or disbandment of the plant to ensure environmental justice for the people of Chaparral. Thank you very much.
Thank you.
Ms. Fiore. So, Mr. Chairman, one quick announcement. I just want to advise all the individuals giving public comment. This is being recorded, and we typically allow a 3-minute comment period for each. And I know Ms. Fiore didn't go over that, but I forgot to mention that at the beginning. Next up, Mr. Chairman, I have a Maria Isabel Gabe, Sister Chavela. And then we'll make a comment in Spanish. If you could please unmute yourself.
Sure, thank you. Good morning. Buenos días. Mi nombre es María Isabel Galve o Sister Chavela, religiosa de la Asunción. Soy una ciudadana residente de Chaparral, Nuevo México, desde hace 20 años. Nuestra comunidad de Chaparral colinda directamente con la planta del Paso Electric en El Paso. Expreso aquí públicamente mis propias preocupaciones y mi oposición a la planta Newman 6 y también la de muchas de las personas de Chaparral. Moralmente hablando, no puedo apoyar un proyecto que va en contra del bienestar de la gente, pone en riesgo la integridad de la creación, compromete la calidad de aire impactando nuestra salud y contribuye a un peligroso ciclo de extracción y destrucción del suelo en otras zonas de nuestro estado. El Acta de Transición Energética de Nuevo México en el 19 fue un paso en la correcta dirección y el resultado del permiso de San Juan afirma el camino claro de fuentes de energía limpia y sostenible en Nuevo México. Muchas gracias, oficiales elegidos de la Comisión Pública de Regulaciones. Sus decisiones son una manera responsable de cuidar el planeta y las generaciones futuras. La propuesta de Newman 6 es un shock para nosotros. Hace varios años, el Paso Electric instaló un número impresionante de paneles solares en Chaparral y últimamente habíamos escuchado que va a poner más. Bravo, lo apoyamos. Pero si Newman 6 se aprueba, las consecuencias para la salud de nuestra comunidad serían irreparables. Los niveles de toxicidad creados por la combustión de tan altos contaminantes liberados sobre nuestra comunidad aumentarán peligrosamente las condiciones de nuestra respiración. Un alto porcentaje de nuestra población ya tiene problemas de asma, condiciones bronquiales y muchas jóvenes embarazadas estarán en riesgo. Y además el viento sopla siempre del suroeste donde se propone Newman 6. La gran ironía es que en medio de nuestro ambiente tenemos la fuente más poderosa de energía renovable y sostenible, el sol infalible e implacable del sur de Nuevo México. Soy una mujer de fe y creo que nuestro Creador nos ha confiado el cuidado de nuestro planeta y sus habitantes. Por favor, consideren cuidadosamente su decisión. Confiamos en ustedes. Que la sabiduría y la rectitud de juicio los acompañe y muchas gracias por su atención.
Jason, Mr. Chair.
Gracias. Yes, Commissioner Espinosa?
What I need to do is ask her something in Spanish to ask her to provide a copy of her message to us so that we can interpret it for the record. Is that fine if I just... Señora?
Yes. Sure. Thank you. I can do that. I will send to you. Thank you.
Yeah, mándame una copia del papel y su mensaje.
Perfecto. Gracias.
Gracias a ti.
Thank you, Maria.
Thank you.
Jason, anyone else?
Yes, Mr. Chair, we have four more. Next, I would call on Joan Brown. Ms. Brown, if you could please unmute yourself.
Yes, good morning, commissioners, and thank you for taking comments today. My name is Sister Joan Brown. I'm a Franciscan sister and the executive director of New Mexico Interfaith Power and Light, and I'm here to address the Newman 6 gas plant. New Mexico Interfaith Power and Light works with faith communities, faith leaders, and individual people of faith and conscience all over New Mexico. And we address the concerns of communities related to environmental justice, ecological well-being, health, and climate change coming from a spiritual, ethical, and a moral foundation. The Sisters of Assumption in Chaparral, and we just heard from Sister Chabela, contacted us about their concerns of the Newman 6 gas plant for their community and asked if we would act in solidarity with their economically challenged and mostly immigrant community. I have also lived and worked in Sunland Park, New Mexico for 8 years in the past with a community on sustainable straw building housing project that community saw as a way to move into the future with more energy efficiency, as they knew they would be disproportionately affected by climate change. So I'm very aware of the concerns of air pollution on the border and for community health because I live that reality. Added to the environmental justice challenges that exist in our border region, we now have climate change as a multiplier effect for a population that is already affected by poor air quality that is only growing more dire. During the COVID crisis, we stand with our border neighbors who continue to face dramatic effects of COVID because of existing health challenges and air quality problems. In addition, our understanding is that the gas for this extension will come from the Permian Basin. New Mexico Interfaith Power and Light is also working with faith leaders and communities in that region of our state to address health problems due to methane pollution from venting, flaring, and wasting in the oil and gas field that is not adequately regulated or enforced. So there's a problem on both ends of this concern. New Mexico Interfaith Power and Light would like to see stronger efforts to move our energy production to even more renewables and better energy efficiency for both new and old buildings and dwellings. We believe that the $163 million project would be a heavy burden on ratepayers, $18.6 million in additional rate revenues in El Paso and $4.6 in Las Cruces. For New Mexico Interfaith Power and Light, this is an issue of justice, equity, and moral and ethical values. We believe it would be better for community health, the growing climate concerns in our desert region, and ratepayers to invest in energy efficiency, renewable energy to meet the needs of El Paso Electric and our communities that need to be served. Thank you very much for hearing this comment and for all of your good work. Blessings this day.
Thank you very much, Joan.
Thank you, Mr. Chairman. Commissioners, next we have Miguel Escoto. Ms. Miguel, I think I saw you. There you are. Go ahead and unmute yourself, please.
Hello, everyone. Thank you. My name is Miguel Escoto, a resident of El Paso, Texas, who has been closely following this proceeding of the Newman 6 gas plant project. This morning, I would like to paint a clear, tangible picture of Newman Generating Station's extraction process to illustrate how the rejection of this project can be a force for good in all of the Southwest region. I am West Texas Field Associate with Earthworks, a nonprofit organization dedicated to protecting communities from harmful extraction projects. September of this year, I accompanied Earthworks Senior Field Advocate Sharon Wilson to inspect pollution from oil and gas facilities that supply the existing Newman Generating Station. Sharon is a certified thermographer of optical gas imaging, OGI technology, a camera that is able to make visible the invisible hydrocarbon emissions from the oil and gas extraction process. At every step of this process, using optical gas imaging technology, we witnessed a horrifying amount of normally invisible volatile organic compounds. That these are emissions that include greenhouse gases as well as carcinogens. Permian Basin oil and gas wells, the source of Newman's fuel, spewed large plumes of methane from venting tanks and flares. At Kinder Morgan's El Paso natural gas pipeline, which would directly feed into Newman 6, we witnessed a devastating blowdown event, which lasted at least 40 minutes. A blowdown event is a process where gas, and by extension, methane and carcinogenic emissions, are dumped into the atmosphere as part of pipeline maintenance. We also visited the Newman generating station itself. OGI technology also detected huge, dense plumes of emissions coming directly from this site. And we plan to email these videos directly to the commission electronically through the Public Records Office. So the status quo of El Paso Electric and the Permian Basin is already an affront to the climate and the health of El Paso, New Mexico, and the world. Why does El Paso Electric think that El Paso, the 10th sunniest city in the world, should be powered only by 5% clean renewable energy when other cities with much less solar potential already have much more clean energy penetration? How is it that our climate has been so polluted to such extreme, possibly irreversible levels? You have the power to be a force for good by affirming the hearing examiner's recommended decision and rejecting Newman 6 gas plant expansion. We need less dirty energy, not more. Thank you.
Miguel, this is Commissioner Fishman. I believe you were at our meeting in Las Cruces when the PRC met down there.
Yes.
Did we meet down there? Okay, well, just wanted to thank you for your interest and follow-up, and your engagement is appreciated and welcome.
Thank you, Commissioner.
Jason.
Yes, sir. Mr. Chairman, Commissioners, next we have Jeanette Lara. Miss Jeanette, let's see here if I can find Jeanette Lara. Miss Jeanette Lara, I have sent you a message to please unmute yourself. I believe you can do so by pressing *6.
Hello?
Yes, thank you.
Hello? Can everybody hear me now?
Yes, I
We can hear you.
Okay, perfect. Sorry, I'm joining by telephone call. So my name is Jeanette Lara. I'm a physician. I actually was born in El Paso and I've been raised in Chaparral. I lived there all my life. Then went to college at NMSU, left to Arizona and came back to serve my community. So as you can probably tell, this is a big issue for me. I am going to be practicing in Chaparral. I am going to be taking care of people there that are going to be exposed to this air pollution. So it's a major health risk. So this is very important for me as a physician and also as a prior resident of Chaparral. I like to call myself a Chaparral alien because I've always been there. So pretty much I'm standing up against this bill because I'm standing up for my community to prevent this permit from passing. I am concerned for the consequences this pollutants will have in this population's current chronic medical conditions, as well as how it can cause new illness. The most vulnerable population are children, and there is a correlation between air pollution and increased prevalence of pediatric asthma. So this means that, to me, this power plant is gonna create more illness, and I am a family medicine physician, so I am all about preventing this. Our environmental health is gonna be really, really affected, and we must not ignore it. This population is more vulnerable. There's less insured people, or there's more underinsured people. And, you know, even an asthma inhaler is going to cost a child around $100 if you don't have insurance. We do not have any hospitals. We do not have enough physicians in town. And this is a great concern for me. Thank you.
Thank you.
Thank you. Appreciate your comments.
Mr. Chairman, the last person on the list today is David Garcia. Good morning, David.
Good morning, Chairperson Fishman, and honorable commissioners of New Mexico State Public Regulation Commission. My name is Dr. David J. Garcia. I am a resident of Chaparral, New Mexico, and representing the citizens of Chaparral through an organization called Chaparral Parents in Action, a 501c3 organization. We live 8/10 of a mile from the present Newman plant. The residents of Northeast El Paso and Chaparral are considered a fence line community. The concerns that we have are very frightening. When you think of all the deadly misgivings, especially when an industry uses fracked fuels to produce electricity. The byproducts of those fuels are dirty pollutants that are poison, drastically contaminate the environment, corrupts and influence climate change, and have a deadly impact on human life and the health of our children. Dr. Jeanette Lara spoke a while ago. She's our family doctor here in Chaparral, claims high incidence of respiratory problems in our community, especially in the children and the elderly. These fumes in form of smoke are known to have carbon monoxide, carbon dioxide, nitro oxide, and the deadliest is methane gas, which spews out of the power plant smokestacks. In many instances, the smoke is colorless and white in color, and people may be deceived of this poisonous nature. We ask ourselves, when this deadly smoke is released by the power plant smokestacks, where do those poisonous particles go? The answer is depending on the speed and wind direction. It eventually falls to the ground. It lands in our backyards, rooftops, vegetable gardens, and worst of all, the air that we breathe. It is your moral responsibility to ensure public safety, to ensure good to our citizens over profit margins. Why do we permit this type of industry to destroy our environment? Talk about systemic injustice. The rich and powerful institution exercising authority over the poor. In my opinion, it is a crying shame because our people are desperate, tearful, and worried and frightened if the Newman plant is to move forward with this expansion. It is just not acceptable. Therefore, please help our people by opposing this dishonest venture that El Paso Electric wants by deceiving the folks from southern New Mexico and the families from Northeast El Paso. Commissioners and Commissioner Fishman, thank you very much for your attention.
Thank you, Dr. Garcia. And I, just so folks know, Dr. Garcia is a former county commissioner in Doña Ana County, and obviously served that Chaparral area. Anybody else, Jason?
Mr. Chairman, that concludes everybody that signed up for public comment today. Thank you.
Thank you. Consent action items is the next agenda item.
I will make a motion to move them as presented.
I would
I'll second that.
make just a quick amendment. I want to spend about 2 minutes on items 4 and 5 regarding the request for disbursements, or I guess that's maybe 5 and 6, if the commission would indulge me. So I'd like to put those aside.
That's fine. I'll amend my motion.
Okay, great. And we had a second from Commissioner Hall?
Yeah, I second and I'll amend my second. That's fine.
Terrific. Michael, take the roll.
Commissioners, this consent action items on the agenda are case 20-00200 TRM in the matter of the application of PSI Medical Flight Services LLC for a certificate to provide ambulance service. Case 20-0019-192 UT in the matter of the application of Hemis Mountain Electric Cooperative for approval of continuation of its fuel and purchased power cost adjustment clause and continued use of methodology. Case 20-00104 UT in the matter of the application of El Paso Electric Company for revision of its retail electric rates pursuant to advice notice number 268. Case 19-00154 UT in the matter of the verified petition of Plateau Telecommunications as a competitive local exchange carrier designated as an eligible telecommunication carrier for limited purposes. Case 18-00103 UT in the matter of the filing of applications for broadband program support from the State Rural Universal Service Fund as per 17.11.10.31 NMPRC.
Excuse me. I just want to make sure we're clear. 5 and 6 we're going to be put on regular action.
Correct.
Oh, sorry. I was just forging ahead.
Yes, I understand.
4 and 5 will not be on the consent vote. Sorry.
Do not ignore me, Michael.
I was on a roll going through those.
Yeah.
Actually, it's 5 and 6. 5 and 6. Items
6.
5 and 6.
Correct.
Okay, I wrote down 4 and 5. 5 and 6. I will skip 6 then. Case 20-00194 UT in the matter of El Paso Electric Company's application for approval of abandonment of Rio Grande Power Plant Unit 6. So this vote, just to clarify, will be on items 1 through 4 and item 7. And I'll take the roll. Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
Commissioner Espinoza.
Aye.
Commissioner Vicente Aguilar.
Aye.
And Commissioner Fishman.
Aye.
Commissioners, the consent action item agendas I mentioned are approved by a vote of 5-0.
I probably should have been a little more specific, but if the commission is amenable, I'd like to just quick cover 5 and 6 before we get to the regular action night. The rest
Yes,
of the.
please do.
Quickly.
Okay, we're good. So it's kind of a nit, but when we get our opinions from staff on going ahead with these projects, we're always saying we see no reason not to disperse. And my understanding is that we do considerable work to be sure that we affirmatively feel like we should disperse. And I really think the language in our orders on these disbursements should reflect the work that we put into this and should give ratepayers more assurance, the ratepayers that fund these programs, more assurance that we've done our homework and this is an affirmative action on our part, not just something we did because we could find no reason not to do it. And I'd like to propose that for these orders and these orders in the future, that our language reflect that we, not that we should be saying we want to make this disbursement is justified, rather than saying there's no reason not to make this disbursement. So I wanted to throw that out to the commission and to staff and basically get folks' feelings and see if we'd want to make that minor amendment on these two particular actions.
Mr. Chair.
Commissioner Hall.
Yeah, I agree with what you say. I think it's not a trivial matter, and we should make sure we send the message correctly. And this is the first time I've seen something like that happen. It's not, impossible for people to make errors. But in any case, we should we should make it clear that we want to disperse.
Any other commissioner comments?
I'll support you. This is Commissioner Espinosa.
Yeah, thank you. And obviously on this one, anyone from staff who's listening in, or Russell, any comments that you might have on this, concerns?
Mr. Chair, Commissioners, this is Mike Ripperger. I mean, I think that it's just a matter of, changing. I mean, there is a review, staff does review to make sure that, they've met the requirements for the initial disbursements, or whichever disbursements, middle or end, that they do. It probably wouldn't be too difficult to just modify language to more clearly reflect that a review has been completed, rather than what you stated, the no reason language can be modified. I don't think it's that big of a deal to do.
Okay, because I know Eugene does put a lot of work into this, and I think our document should reflect that. So, so what I'd like to propose is, I don't even want to try to specify the specific language. Mike, do we need to specify the specific language, or can we just vote to say, let's change that to an affirmative? They've met the requirements for disbursement.
I think we can wordsmith that for you.
Okay, great. And then I guess we need a vote of the commission on each of those items separately, or can we do that together?
I'll move the order to amend it with the minor adjustments.
Second.
And that would be for both 18-00103 UT and for 19-00106 UT.
Should I take the roll?
And yes, go ahead, take the roll.
Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
Commissioner Espinoza.
Aye.
Commissioner Vicente Aguilar.
Aye.
Commissioner Fishman.
Aye.
Commissioners, the orders as modified in 18-103 and 19-106 are approved by a vote of 5-0.
Thank you, commissioners, for indulging me on that. And Michael, I think you and your staff deserve more credit. So let's have language that gives you the credit.
I don't know if I can put that in, but
I was talking to Michael Ripperger.
Oh, okay. I still don't think we generally put that in.
Okay. So regular action items. Transportation matters, item 20-00181 TREN, the formal complaint of Wendy Jo Ashworth and of David Killinger against Running Bear Rescue. And Hans, I guess you're taking this one.
Yes, thank you, Mr. Chairman. Good morning, Mr. Chairman, fellow commissioners. This matter comes before the commission on its own accord from this office, based on the investigative reports submitted to the commission by investigators James Martinez and Crespin. As the commission may be aware, the order for staff investigation was entered on October 28th, 2020, I should say, requiring staff to investigate the alleged violations named in the complaint and respond by November 16th, 2020. Investigators Martinez and Crespin posted investigations during November 10th through the 13th. Those reports were filed November 17th. And the reports detailed numerous violations, including but not limited to drivers that operate ambulances without pre-employment drug screening, background checks, and Department of Transportation physical certifications, driving ambulances prior to CEVOC training, no work orders for ambulances requiring maintenance, ambulances put into service prior to PRC inspection, entering patient care reports without driver's names or alternate driver names, and operating outside of its licensed area. These violations would stand counter to Federal Rule 382.215 and NMAC 18.3.14.23, 18.3.4.10a, 18.3.14.12c, 18.3.7.14a, 18.3.7.14a, and 18.3.3. The commission has authority under NMAC 18.3.2.26 to suspend or revoke the operating authority of a motor carrier if it is satisfied that the facts show that a motor carrier's operations endanger the public health and safety and merit immediate temporary suspension. My proposed order that I have circulated to you would propose the following: that division staff shall file a written update by December 9th of the violations found in the prior report. In the event that update establishes that the violations continue to endanger the public health and safety, those violations shall merit immediate temporary suspension at an emergency open meeting on December 14th, 2020, where the commission would decide whether that temporary suspension should be issued. The respondent shall be given due process by being able to file a written response to this order to show cause within 20 days, and another written response within 2 days of the written update being filed, or if an immediate suspension is ordered. That written update should show cause why the respondent should not be found in violation of the safety violations, why it should not be assessed fines of not more than $10,000 for each violation, why its operating authority should not be permanently suspended or revoked, and why its operating authority should not be temporarily and immediately suspended until a final order in this matter is issued. My proposed order stands as my recommended course of action in this matter. And with that, I'll stand for questions. And I believe that Attorney Padilla, on behalf of Running Bear, has been authorized to speak at this open meeting. I'll have to refer to Chief of Staff if he is currently available.
Jason?
Yes, Mr. Chairman and Commissioners, I believe the Office of General Counsel has provided Mr. Padilla.
Whoops, we're having trouble hearing you, Jason.
Can you hear me, Mr. Chairman?
That's a little better.
That's better.
Sorry about that. I think my microphone kind of faded out a little bit. But anyway, I believe the Office of General Counsel has provided Mr. Padilla.
Oh, you're gone again.
Can you hear me?
Now I can.
I don't know what's going on. I'm sorry, my speaker seems to be fading out, but I'm trying to say.
I've always been able to hear you on my end.
Okay, I'm trying to say that the Office of General Counsel has provided Mr. Padilla with today's open meeting information. If he is on the phone, he could be called upon by the commission, and he could just press *6 to unmute himself.
Jason, before we go any further, I would just like to make it clear that what the Office of General Counsel is presenting was noticed on the agenda as a potential order to show cause. This is the matter that we're discussing, and it has two parts. One is an order to show cause on all the matters, including non-public health and safety matters. and that has 20 days to respond, and it would be heard on the April 12th date that Carolyn Glick as hearing examiner has already set. And then the second component is an order to show cause why there shouldn't be an immediate temporary suspension. That, in that respect, Mr. Padilla and his client would have 2 days to respond from the updated staff investigation, which should occur no later than, I believe it's December 9th. And then if those allegations demonstrated continuing health and safety violations, there would be a special open meeting of the commission on December 14th at 9:30 a.m. And there would be a hearing before the entire commission. And we're proposing that Carolyn Glick would act as a presiding officer, but not a hearing examiner. She would not issue an RD. She would rule on evidentiary matters. And that special open meeting would be a hearing before the commission, and the commission would then determine whether or not to immediately temporarily suspend Running Bear's operating authority. I just wanted to make all of that clear before we went. If it wasn't already clear, maybe this is overkill, but that being said, and
Thank you.
That was very helpful.
Mr. Chair,
Yes,
Commissioner Hall. Based on what Judy said and what my understanding is, I don't think this is an appropriate time to hear from opposing counsel. I mean, there's an opportunity next Monday morning in that matter, and we're not noticed to be having a hearing today, and I don't think it's appropriate to entertain any arguments from the counsel in this case.
Commissioner Hall, I would agree with that. It hasn't been noticed as a public hearing. And there will be sufficient opportunity to respond, both in writing after staff files its updated investigation, and then if the commission wants to go further, there will be a special open meeting, which will be a public hearing. And at that time, Mr. Padilla will be able to present an entire case.
Correct.
Thank you, Judy, for that.
Mr. Chairman, Commissioners, I just wanted to give you the heads up, which was that I had suggested that Mr. Padilla be allowed to address the commission, however, only on the limited issue. He had sent an email this morning basically objecting to the commission considering this order in front of the commission and analogizing this to a entity, or rather a party seeking a temporary restraining order in pursuit of a preliminary injunction, which is done on an ex parte basis, which is in essence how this order to show cause is being brought from the commission on its own initiative. If I were an attorney in court and the opposing attorney appeared in court on what would be otherwise an ex parte application, I think the other attorney would have the ability to respond as to whether the court is authorized to take the action that it is taking. So for purposes of this, if Mr. Padilla does not believe that the commission has the authority to issue an order to show cause, in which he will then have the opportunity to respond substantively and participate in an evidentiary hearing, then I think it'd be appropriate to hear from him on that limited issue. This is not an opportunity for him to respond to the allegations in the order to show cause. This is not an evidentiary hearing. And so it was only for that limited purpose that I said that he could be permitted to have a phone access to this meeting.
Mr. Chair, can I please ask a question of Mike?
Sure, go ahead, Commissioner.
Mike, are you saying that because the council doesn't believe that we have the authority to issue an order to show cause today, that he wants to address that issue before us now, and you thought that might be okay? Is that what you just said to us?
Yes, actually what I'm saying is normally this normally does not come up as an issue. And this is somewhat of an unusual circumstance. And to the extent that I personally do not think that there is any argument that the commission does not have the ability to review the submission in a case that's pending, in this case, the reports from staff, and on its own initiative, issue an order to show cause, which is not any kind of substantive action against his client. It's merely, in essence, the potential beginning of a case. It is, in essence, a complaint by the commission against a regulated entity, and that basically they are required to respond to. So he has not been deprived at this point. His client has not been deprived of the opportunity to respond to anything at this point. If he believes that somehow, and he is basically raising this, that somehow the commission taking this action on its own and issuing an order to his client somehow violates his client's rights, then I don't have a problem with hearing what he has to say on it.
And Mr. Chair?
Yes, Valerie.
I didn't mean to cut you off, Mike. I didn't realize that you were not done. I do want to hear from the gentleman, and I don't think we should debate this any longer. Based on what I've heard, it's acceptable and there are rights involved, and I don't see any harm in this, and we need to move along rather than going back and forth between attorneys. I trust that Mike Smith knows what we need to do here, and so I would like personally to hear what the other side has to say, and I'm sure there are boundaries and he's heard what they are, so we should go ahead and allow the gentleman to speak.
Yes, Commissioner Espinosa, I agree. And what I'd like to do, Michael, if this works, and if this works for the other commissioners, is allow the gentleman 5 minutes to speak to the specific, I guess this is the procedural issues that are in play here. Does that make sense, Michael?
Mr. Chair? Mr. Chair?
Yes, go ahead, Cynthia.
Well, I'm opposed to listening to him, but if other people want to do it, I would give him maybe 3 minutes. I think it's very clear that we have the right to do what we're doing, and we have a long agenda, and I don't think this should merit very much time at all.
Okay, I'm cool with.
We decided on 5 minutes, and I really wish we would stop spending time disputing this.
Okay, if I'll just make a decision here. Let's just go 5 minutes, and
that's good.
We'll go from there. Is the attorney here?
I'm on the phone, sir.
Okay, why don't you, got 5 minutes, would like to hear your case.
Thank you, sir. Mr. Commissioner and the commission as a whole, my name is Ray Padilla. I'm an attorney. I represent Rocky Mountain EMS, which is the company that's the subject of this motion or petition. It's not quite clear to me whether it's a motion or petition, but what is clear to me is that this motion is forcing my client now to litigate the same issues in two separate forums, one forum being the commission itself, and the second forum being a hearing that's already been assigned to hearing officer Carolyn Glick in this particular matter. The motion, the caption of the motion shows that it emanates from two formal complaints that were filed, one by a lady by the name of Wendy Jo Ashworth and another by a gentleman by the name of David Killinger. By the commission's own rules, and I'm quoting from rule 1.2.2.15, the filing of a formal complaint shall commence a formal proceeding. So this is already a formal proceeding, and this commission has already assigned the matter to hearing officer Glick, which is set forth in the motion itself at paragraph 8. Now, the problem that my client has, and the reason that my client believes that the commission shouldn't be hearing this matter and that this is being done prematurely is, first of all, I got notice of this motion by an email that was sent to me at 4:53 p.m. yesterday afternoon, which is 7 minutes before traditional closing time. It's a 43-page motion. Luckily, I happened to look at my email after 5 o'clock and found that the motion is there. The motion was filed by staff in these two cases, and if you look at the motion in paragraphs 8 and 10, it shows that there's already been a pre-hearing conference in this case, and that there's already been a procedural order set by hearing examiner Glick, and that hearing examiner Glick intends to hear evidence with regard to two of the reports that are referred to in the motion but aren't attached to the motion as an exhibit. Only one supplemental report is attached to the motion, and last night was the first time I had an opportunity to take a look at that. In any event, this motion appears to be an attempt to bypass the process that the commission has already put into place, and that is to have the hearing examiner rule upon motions and have a full-blown hearing in this particular matter. The motion is, in our opinion, also has a substantial prejudicial effect on three other matters that are currently pending before hearing examiners. There's a matter of an application for a company by the name of Helios that wants to obtain a new license in Santa Fe. There's another company, AMR, who's trying to get an ambulance license in Albuquerque. And there's a case that's been pending against my client for over a year that's set for hearing on January 4th through the 8th of 2021. And it's the exact same issues that we're talking about here. My client is extremely concerned that it's being denied its constitutionally protected due process rights, and that's the right to notice, the right to respond, and the right to hearing. Now, I heard this morning that for the first time that there would be an updated investigation and that there would be an opportunity to respond. First of all, let me say that there's a hearing that's being proposed for the 14th of December. I'm going to be in a hearing in another matter involving the PRC and this same client on December 14th, and I can't be in two PRC hearings at the same time. So that's a problem. And we've got, I think, substantial issues with regard to that. Furthermore, the motion violates Rule 1.2.2.12E1 of the Commission's rules because I was never contacted to determine whether I was opposed to this motion or whether I concurred in the motion, and neither were Ms. Killinger or Ms. Ashworth or Mr. Killinger to my knowledge. So that's a problem. I understand that I'm not allowed to argue to you the merits of this particular case, but Mr. Mueller started out his discussion with you arguing the merits of this case, and now I'm not allowed to respond to that, and I respect the order of the commission saying that I can't respond, but I think that that's, again, prejudicial to my particular client. Furthermore, at this point, there's just allegations that need to be proven, and immediate suspension is an extreme sanction. There hasn't been any probable cause found by the commission at this point in time with regard to these new allegations. And again, we've been ordered to, there's a hearing examiner that's been appointed, and we shouldn't be allowed, or we shouldn't be required to essentially defend this matter on two different fronts. One front being the commission and the other front being the hearing examiner. So I think the commission needs to follow the procedure that it's already established and let hearing examiner Glick follow through with the procedure that she's already set up and the actual hearing that is going to take place in April. And this matter can be fully dealt with in that scenario. And because of that
circumstance, your 5 minutes here, so try and wrap it up.
Because of that circumstance, because there's already a hearing examiner that's already dealing with all these issues, I don't think it's appropriate for the commission to intercede at this point in time and essentially take the action that the commission has already delegated to hearing officer Glick to make recommended resolutions on. Thank you. I'll stand for any questions if anybody has any.
So thank you. And actually, I'd like to hear from our attorneys first, Michael and Judith.
Mr. Chairman.
Commissioner Fish, Chairman Fishman, and Commissioners, if I could respond to just a couple of the comments that Mr. Padilla made. First of all, I think the motion that he referred to is currently not before the commission. That was a motion filed by staff, as Mr. Padilla indicated. That is not the motion that I have brought before you today. As I indicated, this is brought to you on the own accord. The Office of General Counsel is responsible for this matter. And this is brought to you, essentially, we are obligated, we are required under statute to bring this before you under section 18-3.2.26, which reads, upon receipt of sufficient information that a motor carrier's operations endanger the public health or safety, we shall present to the commission at its next meeting or at an emergency meeting the safety requirement that has been violated and all facts known to the director. As I just read, that language is shall. We are required under statute to bring this before the commission. And essentially all we are doing today is setting up the special emergency open meeting to determine whether or not a suspension is appropriate. So I would suggest under statute, we are required to do this based upon the sufficient information that was contained in the investigative reports of our staff. We can't do that on a formal complaint because those are alleged at that point. However, based upon investigative reports being filed and sufficient information that safety violations that endanger the public are present, we are required to bring this to you to set up that time. I would suggest that my proposed order actually allows for additional due process beyond what the statute even requires for Running Bear and Mr. Padilla to respond. As I indicated earlier, the statute actually allows the commission to consider immediate suspension. However, my proposed order would allow Mr. Padilla time to respond. If Mr. Padilla does have a conflict with the proposed date, he can definitely request an alternative time. However, that should be done on an emergency basis.
Thank you, Hans. Michael and Judith, do you have any further comments on this?
This is Michael Smith. Commissioners, and Mr. Padilla, I would just point out that Mr. Padilla raises issues about the individual complaints that were filed by two persons in the community against Running Bear, and indicates that somehow, or argues somehow, that the commission is precluded by the fact that it's hearing a complaint on a specific subject or allegation, that the commission is somehow precluded from conducting its own investigation or expanding the scope of the remedies available in connection with those alleged violations of commission rules or state statutes regarding his client. And I believe that's a fundamentally wrong interpretation of the commission's duties to the public. And the commission is not bound to allow an individual member of the community to prosecute their complaint-related entity. If the commission sees in the context of a complaint that's brought by a private person, indications that a regulated entity is continuing in this case to potentially violate the rules and regulations governing that entity, the commission has an obligation, and this hits on what Hans was just saying, the commission has an obligation to protect the public interest and to convert that private complaint into or expand the scope of the proceeding into an order to show cause proceeding, which at this point, those private complaints are not in the context of being an order to show cause, which could result in actions such as fines or suspension of the regulated entity's authority.
Yes, and the only thing I would add is the statutory authority for the commission to temporarily and immediately suspend a motor carrier's operating authority for public health and safety reasons is found in section 65-2A-27. And that's just one point. And then the second point is this potential order would change the matter from, which started out as 2 complaints, into an order to show cause case, as Mike stated. And the caption
Mr. Chair.
would change.
Mr.
Comments
Chair?
and questions from commissioners?
Yes, sir, Mr. Chair. Again, can you hear me?
Yes, go ahead, Commissioner Espinoza.
I guess I would have questions for Jason, actually, or maybe I'd like to hear from Jason in terms of what his input is at this time, because he would probably be representing staff. But I think we need to hear a little bit more from Jason, and if that's possible.
I agree. And Jason, can you comment
Yes, Mr.
on where the Transportation Division is on this?
Yes, Mr. Chairman, Commissioners, can you hear me okay?
Give it a try. I can hear you, but you're jarbled a little now.
Okay, I don't know what the issue is. How's that? Any better?
Yes. You should probably take it off speaker, maybe.
Give me 1 second, please. Sorry. Mr. Chairman, can you hear me?
Much better.
Okay, thank you. How's that still?
Still working.
Good job.
Okay, sorry, I don't know what's going on. It has to be, we got a lot of snow here at my house, so I'm wondering if that's impacting quite a few people here up north. But I would just like to take an opportunity and echo what Mr. Hans Moeller has already referenced. And in the rules, specifically 18.3.26, upon receipt of sufficient information that a motor carrier's operations endangers the public health or safety, the director, in this case myself, shall present to the commission at its next meeting or at an emergency meeting the safety report. And it continues on and on. But I just want to say that this is now my presentation. The order to show cause that we're referencing on behalf of staff filed yesterday is in response to the sufficient information that has been collected over a long period of time. Mr. Padilla himself recognizes that the case being heard before the hearing examiner, Carolyn Glick, in the 2019 case is the exact same issues. So these continue to be repeat violations that are found after every investigation. Staff are ordered to go out and conduct. My only other response is if the order goes, if I'm understanding it correctly, my concern is pre-employment background checks, pre-employment drug screening cannot be corrected. The employees have already been hired and have been driving. And so will the violations continue? They exist. There's no corrective action for employees in pre-employment situations. And so that has continued to be a repeat violation over time. There is a substantial amount of information in Mr. Vince Crispin's report. I don't know how much into the details we can get because it was filed under the cases on the agenda today, but that in itself should raise an extreme amount of concern on my behalf. And therefore, per the rule, I am bringing this to the commission's attention as I am required to do so. And then I guess the commission then decides if that is satisfied with the facts. I know our report, filing from yesterday may appear quite lengthy, but for the most part, it copies the statutes and rules that have been cited in the investigation reports. So, you know, that's just verbatim information. It's the front end information, and then the conclusion within that filing that really draws the attention to the sufficient information that, in our opinion, endangers the public health or safety. So I just wanted to make that that argument on behalf of staff. I don't know, I guess the more investigation conducted on behalf of staff, the more is discovered. And so, you know, again, pre-employment background checks, pre-employment drug screening cannot be corrected. Therefore, how does somebody take corrective action to address those situations?
Jason, real quickly, does the filing that was done yesterday make any recommendations?
Chairman Fishman, before he responds to that, I would, at this point, I need to advise the commission that essentially, since that motion was filed after publication of the agenda, there would be Open Meetings Act reservations about considering that. I would suggest that, as I have not referred to that motion at all today, I have not referred to the relief requested in that motion today. I would ask that Mr. Montoya, as indicated, is free to bring that presentation at the emergency meeting.
Okay.
So we don't
gotcha
issues with Open Meetings Act.
Yes, Mr. Chairman, it does state that the presentation to the commission at its next open meeting or at an emergency meeting.
Okay. Other questions from commissioners?
Yes, Mr. Chair.
Yes, go ahead.
I do want to acknowledge, you know, the two inspectors, Vince Crispin and James Martinez, for their hard work and their efforts put forth in this. And I do realize that we cannot proceed unless we move the order that is before us. And so, unfortunately, with that, I'd like to go ahead and move the order for all legalities involved that were stated earlier by both sides and all sides. And I do see a critical problem in hopes that, you know, nothing occurs in the meantime. But I think we have to follow direction from legal counsel and move the order. With that, I'm going to move that order.
I'll second it.
Any other comments? Michael, take the roll.
Before you vote. Could we address the issue of Mr. Padilla being unavailable? He said on December 14th at 9:30 a.m. because he was
Judith, can we move it up to prior to the 14th? Because it seems like it's a dire need. So I think instead of kicking it down the road, I think it needs to be done sooner, because I'm sure the 5 of us could be available sooner than the 14th.
Yes.
Another point of order here.
Go ahead, Commissioner.
I think Mr. Mueller addressed that. It would require an emergency response by Mr. Padilla.
Yes, he would.
We still have to meet.
We still, even he responded, we would have a special meeting, and he said he's not available on the proposed date. We could move it up. The prior week is free, but except for the commissioners were attending a continuing.
That's okay. I think we need to move it up instead of past. So on the week of December, is it the 7th through the 11th? Then we should probably do it any day that anyone's available. That gives sufficient time for notification. So even on the 11th or 10th, probably the 11th would be best.
I would just, Commissioner Espinoza and fellow commissioners, I would just note that that would not be the only timeline that would need adjustment. Currently, we have staff filing the updated written update by December 9th and allowing Mr. Padilla 2 days to respond to that. So,
well, he's not available
have
on
to
the
be,
14th, so.
Yeah.
Another thought here. It sounds like that there's 2 hearings scheduled simultaneously. Is it possible to schedule it one's at the beginning of the day and the other is later in the day? And that would provide an opportunity for legal counsel to be at both.
You'd have to ask him, Mr. Montoya. He's the one that's not available on the 14th.
Mr. Chairman, Commissioners, I'm just looking at the commission's calendar, and it appears that case, I'm not sure, actually.
It's 20-00125.
It is, okay.
It's the Helios matter, and it's before Robert Lennon, and it potentially could go 2 days.
Okay.
I might suggest Friday, the 13th. Sorry.
You mean the 11th?
Wait. What day? Okay, the Friday the 11th, right?
Yes, that's what I suggested earlier.
That could work.
Mr. Chairman, this is Ray Padilla, and I know I'm not allowed necessarily to participate in this, but I have a deposition on the 11th in another PRC case.
Yes,
then maybe we should move that deposition, since this is a matter of life safety.
Yes, Mr. Padilla's deposition isn't scheduled until after 2 p.m.
So we could do this early in the morning, same day.
I see hearing examiner Lennon. And do you have any thoughts on this?
Yeah, I do. I just wanted to comment with your permission. Thank you. I've been online the whole time. The hearing on the 14th is where Mr. Padilla's client is an intervener, and I'm sure he wishes to cross-examine. It's relatively complex. There are a lot of interveners. It's expected to take the entire day, and I believe it will continue into the Tuesday, the 15th. Like I said, his role there is counsel for an intervener. There you go.
That still doesn't interfere with the 11th.
No.
Yeah. Commissioners, Smith, it seems like given the limited nature, scope rather, of the that we're trying to schedule, that the morning of the 11th should be sufficient to address that.
So let's go ahead and move with that.
I would just make the following suggestion, amendment to the order then. I would have staff file their updated report by the 8th, allowing Mr. Padilla the 2 days to respond to that written update by the 10th. So we have all that information on hand for and filed by the 11th. So
You have that, Judith?
change that in the order if that's acceptable with the commission.
Okay. Well, that sounds good. Robert, you're in good shape with that? You're on mute. We can't hear you.
Excuse me, I need to unmute myself. You're right. Sure, it's fine with me. It doesn't affect me at all at that point. Appreciate
Okay,
it very much for your
terrific.
consideration.
So did we had a Valerie? So we've got your motion with the amended dates.
Yes. And that would be
Mr. Chair.
for Friday, the 11th at 9 a.m.
I believe I have it for 9:30, Valerie, or Commissioner Espinosa.
That's fine. That's fine. That's fine. Go ahead, Commissioner Byrd. Sorry.
So I'm fine with that, other than I have that mandatory training class I got to be in all
It ends
next week.
It ends. It ends on Thursday, I think, or half day Friday, but it won't take long.
Okay. I mean, I don't mind being there, but if I don't get my certification, I just want Mike to know why and be okay with that.
Unfortunately, Commissioner Byrd, I don't have any authority to say okay or not. So if there are classes that morning, then are there other commissioners attending that morning? Who would
I
not be
still
able-
say this is by far more important. You can take 10 minutes out of your day, Commissioner.
Commissioner Byrd, I think there are ways that we can ensure you get your full hours credits and still participate. And I can talk with you offline about how to do that.
Oh, I can do 2 phones. I'm just saying there could be a conflict.
Okay.
In addition, this may unfortunately take more than just a few hours for this evidentiary hearing. I mean, I just want everyone to be aware that the last time there was a hearing on an immediate suspension, it went at least 4 hours.
My thought is that this is a public safety issue. It's ongoing.
Thank you.
We should address it urgently. I totally agree with Commissioner Espinosa, and I'm pretty sure the rest of the commission agrees.
Oh, I agree.
Yeah, so
Then let's do it and
let's
move
do
to
it,
the next
and
item.
we'll figure out a way to make it work.
I've seen people not even pick up their certificates or attend the full session, so I commend you for being so honorable. But in my 8 years, I've seen commissioners don't even show up, so I wouldn't worry too much. You can make up your class, but you can't make up a life.
But I can't do it in this year.
I didn't hear you.
I think Commissioner Byrd
Of course
has
not.
no other opportunity to get his credits during this year.
They'll make
Correct.
it up.
Okay, are we ready to, we've got a motion, we've got a second, and I think we're settled now on the dates on the 11th. And Hans, we're settled on the 8th to get all the filings in from
The
staff.
8th will be the written update, correct?
Okay, terrific. And Cynthia, you seconded? Okay,
Yes.
great, she's nodding. And Michael, can you take the roll?
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Espinoza,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman.
Aye.
Commissioners, the proposed order is passed by a vote of 5-0.
Okay, next item. Inquiry into amendments to NMPRC Rule 179572 relating to the renewable energy rate rider And Judy, this is yours.
Yes, and this matter could have been brought on consent, but Commissioner Fishman, you did request that we issue an order regarding the second part of the renewable energy rulemaking, having to do with whether or not the renewable rate rider should be eliminated.
Right.
And this order requires staff to file a response to the following questions, and other participants may respond no later than March 2nd. I could move up the date, I could move down the date, but I was trying to make it so that I know it falls still within the legislative session, but so I could move it, and that'll be your choice. But here are the questions, and they actually are the same questions that Hearing Examiner Glick posed in the SPS renewable case 19-00134, but they would instead be opened up to the entire public and the other utilities. And the first question is there a statutory requirement for public utilities to recover the cost of renewable energy procured to comply with the renewable portfolio standard through a rate rider? Do the renewable energy rate riders provide consumers useful information? Do the renewable energy rate riders provide the commission with useful information? What purpose do renewable energy rate riders serve when renewable energy is becoming less expensive and sometimes less expensive than non-renewable energy? What purpose do renewable energy rate riders serve as renewables are becoming and are required to become a larger and larger percentage of a public utilities energy portfolio? Could costs be saved and customer charges reduced by eliminating the renewable energy rider? Could customer confusion regarding rates be reduced by eliminating the renewable rider? If the commission were required to eliminate the renewable rider by changing Rule 572, please propose the most efficient path for doing so. And finally, if the renewable rider is not eliminated in total, should the renewable rider be line loss adjusted, as is the fuel and purchase power cost adjustment clause? And those are the questions that are being asked. And if any commissioner has any other question, I could include that into the order.
Mr. Chairman, if there are no other questions, Mr. Chairman?
Yeah, Commissioner Hall, go ahead.
If there are no other questions, I'd move the order. I think these are good questions.
Any other commissioner comments?
I have a question.
Go ahead, Commissioner Burr.
I'll let Commissioner Espinoza second it. So is there a possibility to question the basis of a question?
Yes.
So number 4, although it's true the last 10 years we've seen great reductions in costs per outcome, the probability of seeing that over the next 10 years is almost non-existent. So is that a question that really warrants time to deal with it?
I think you have a valid point, and you could change the question to say, what purpose do renewable energy rate riders serve? Period. And end the sentence there before the word when.
Yeah.
I
Just a thought, but I'm good with this.
Yeah, I have no problem with making that change to question 4. I'm not sure how other we have a motion. I'm not sure how the folks who made the motion feel.
You made a basic motion without the questions responded to, so it would need clarification from Commissioner Hall.
You know, I think the full language provides some context and gives some further guidance to what kind of information is supposed to be elicited. I'd prefer to keep it a full sentence if you don't mind.
Okay. The motion, there's no change to the motion being proposed here.
Seems that way.
So
I'll be second.
Okay. Terrific. So we have a motion, I guess, from Commissioner Espinosa, a second from Commissioner Hall, or I might have that backwards. Or I've got it correct.
I made the motion.
Okay. So any other comments from commissioners? Okay, Michael, could you please take the roll?
Commissioner Byrd.
I'm good with it.
I'll take that as a yes.
Yeah.
Commissioner Hall.
Aye.
Commissioner Espinoza.
Aye.
Commissioner Vicente Aguilar.
Aye.
And Commissioner Fishman.
Aye.
Commissioners, the proposed order passes by a vote of 5-0.
Thank you, Judy. On next to item 20-00182 in the matter of the application. In the matter of the application of Public Service Company for approval of renewable power agreements and energy storage agreements and proposal for demand response plan. So we've got Ashley and Anthony. Who's going to take this?
Mr. Chairman, Anthony's going to be taking this. Go ahead, Anthony.
Sorry, Ashley. Good morning, Mr. Chairman and Commissioners. Before you for your consideration is the recommended decision Ashley and I issued in this case on November 13th, 2020. This case is a spin-off or continuation, if you will, of case number 19-195 UT, where in its final order issued July 29th, 2020, the Commission approved the CCAE1 portfolio of replacement resources for PNM's abandonment of the San Juan Generating Station. The CCAE1 portfolio approved by the Commission contains 950 megawatts of resources, which essentially consist of three hybrid solar generation and battery storage projects, as well as a demand response plan. Only 3 of the purchase power agreements, or PPAs, and energy storage agreements, or ESAs, needed to effectuate the solar and battery storage projects were in evidence in case 19-195 UT, and thus were approved in that case. Those resources, which incidentally are listed in blue typeface in the table included in my email cover message sent to you on November 17th, which in and of itself is a reproduction of the table appearing on page 8 of the recommended decision. Those resources were the 300 megawatt Arroyo Solar Project PPA, the 50 megawatt Jicarilla 1 Solar Project PPA, and the ESA for the 20 megawatt Jicarilla Storage Project. Now, in this case, PNM presented 5 sets of agreements for Commission approval pursuant to Rule 551. They represent the remaining CCAE1 resources besides PNM's proposed demand response plan, which the Commission will be considering in case number 20-00218 UT. The 5 include the first First and Second Amendment to the Arroyo Solar PPA to update the PPA pricing terms for the First and Second Amendments to the Arroyo Storage ESA, which increases the total battery storage capacity from 40 megawatts to a total of 150 megawatts, as required to address changes in project capacities approved in the final order in 19195 UT. Second is the 200 megawatt San Juan Solar One project PPA, pursuant to which PNM will pay $26.31 per megawatt hour over a 20-year contract term. The third in this case is the ESA for the 100 megawatts of battery storage project, the so-called SJS1 storage project ESA, which is connected to the San Juan Solar One project PPA. Pursuant to that agreement, PNM will pay a monthly capacity payment of $770 per kilowatt per month over the 20-year contract term of that agreement. The fourth is a PPA for 100 megawatts of solar production from the Rockmont Solar Project PPA. Pursuant to that PPA, PNM will pay $27.35 per megawatt hour over a 20-year contract term. And finally, the ESA for 30 megawatts from the Rockmont Storage Project ESA, which is connected, of course, to the 100 megawatt Rockmont Solar Project. Pursuant to that agreement, PNM will pay $7.99 per kilowatt per month over a 20-year contract term. The appendix at the end of the recommended decision includes maps showing the location of the San Juan Solar One SJS1 project, the Rockmont Solar and Storage projects, together with tables describing milestone items and completion dates for the projects. PNM claims that the agreements, as executed, are less expensive than the indicative pricing for these same projects considered in case number 19195 and result in net present value savings over 20 years of approximately $2.5 million over the project's initial cost estimates in case 19195 UT. PNM insists, however, that the PPAs and ESAs need to be approved by the Commission no later than December 4, 2020, by Friday, in order to have final non-appealable orders by the regulatory end date, January 5, 2021, set forth in the San Juan Solar SJS1 and Rockmont PPAs and ESAs, in order to achieve the in-service date of June 2022 for all of the resources. I should also note that in addition, as discussed on page 16 of the recommended decision, PNM presented updated evidence concerning the economic benefits associated with the resources encompassed in the CCA E1 portfolio. According to information provided by PNM's resource developers, the resources associated with the CCA E1 portfolio represent total investments in New Mexico of between $1.13 billion and $1.16 billion. Of this amount, it's estimated that between $558 and $618 million will be located in the Central Consolidated School District. The total estimated state property tax revenues from these investments are estimated to equal $5.35 million in the first year, with $3.1 million of that amount within the Consolidated School District. The table on page 17 of the recommended decision provides a more granular level of detail regarding the estimated economic impacts associated with the resource projects. And I pause at this point if the Commission would like to ask any questions regarding that table or anything else I've said to date. If not, I'll move on. PNM also presented an alternative resource scenario called the alternative portfolio in PNM witness Thomas Falgren's testimony as a potential substitute for the foregoing PPAs and ESAs. PNM presented the alternative portfolio as a first amendment to the San Juan Solar PPA. It would increase the size of the San Juan Solar project from 200 megawatts to 299 megawatts. And as a first amendment to the storage project ECA, the SJS1, which would increase the size of that storage project to 130 megawatts from the 100 megawatts currently proposed. PNM claimed that the implementation of the alternative portfolio could save approximately $22.7 million on a net present value basis compared to the combination of San Juan Solar PPA, SJS1, and the Rockmont PPAs and ESAs. Now, the parties submitting testimony, CCAE, San Juan Citizens Alliance, DINE, CARE, New Mexico Area, Western Resource Advocates, and staff are taking active positions in the case, including New Energy Economy and SWG. All but one of those parties in the case, that being New Mexico Area, favored the 5 sets of agreements that we eventually recommend approval. And those are the remainder of the CCA1 portfolio of resources filed in case 19195. And many, including WRA, New Energy Economy, SWG, and staff, urged the commission to reject the alternative portfolio. However, touting the apparent substantial savings of the alternative portfolio, New Mexico Area recommended approval of the alternative portfolio if the contingencies identified by PNM witness Falgren had been satisfied by the developer. If not, New Mexico Area, like the other parties, recommended approval of the remainder of the CCA1 portfolio of resources. In the recommended decision, we recommend that the commission approve the Arroyo PPA and ESA amendments and the new PPAs and the new PPAs and ESAs for the San Juan Solar SJS1 and Rockmont projects. Those recommendations are set forth in the recommended decision on pages 36 to 37 and 37 through 38. We find there that these agreements already ordered by the commission in 19195 ET in approving the CCA1 portfolio are needed and will provide customers a net public benefit over the duration of their terms. We also recommend that the commission reject the alternative portfolio for the 5 sets of reasons discussed in the recommended decision on pages 38 through 42. In a nutshell, while this proceeding was conceived to perform an expedited Rule 551 review of agreements for projects the commission had already approved in case 19195, following a compressed and streamlined procedural schedule, the alternative portfolio, while seemingly attractive at first blush, given the alleged substantial savings claimed, presents at least 5 significant issues that could not be reasonably addressed in this case. First, the alternative portfolio is inconsistent with the commission's directives in the final order in case 19195 UT to present agreements for the balance of CCA1 resources. Second, the alternative portfolio did not undergo the exacting scrutiny that the CCA1 resources went through in the last case. Third, the alternative portfolio presents a number of open issues regarding additional risk in concentrating major resources in a single vendor, the so-called all eggs in one basket conundrum, and the vendor's inability to satisfy contingencies of gaining additional site control and finalizing its construction contract before it could commit to deliver the larger projects in a timely manner. Those issues would require more careful vetting than this expedited proceeding is equipped to handle. Fourth, the 299 megawatt size of the solar facility was nominally sized to evade a siting review under the control location statute, which covers generating facilities sized at or greater than 300 megawatts. And fifth, the alternative portfolio raises reasonable and substantial concerns over the integrity of the RFP process and fairness to other bidders. In any event, if approved, the recommended decision provides for PNM to recover the energy charges of the 200 megawatt San Juan Solar 1 project and the 100 watt Rockmont Solar project through its fuel clause, and recover the battery project capacity charges for the Arroyo, SJS1, and Rockmont storage projects through base rates in PNM's next rate case. Finally, addressing the apparent controversy over PNM's update on regulatory asset costs through the testimony of Thomas Baker, that's addressed on in the recommended decision on pages 42 to 45. The recommended decision simply provides that nothing in this commission's final order in this case should be construed as establishing any presumption of prudence or reasonableness of any components of the summary of estimated costs of the regulatory assets described in PNM Exhibit TSB 2 to the Baker testimony, or constitute any rate-making determinations by the Commission regarding PNM's ability to recover any of those costs, or any associated carrying charges in any future general rate case in which PNM may seek recovery of the listed costs. I should also note that during the open meeting, I issued an errata notice and order to the recommended decision that went out to the parties and was provided for filing in the record. So, Mr. Chairman, with my presentation now concluded, we'll stand for any questions the commissioners may have.
Commissioners.
Mr. Chairman.
Commissioner Hall.
I would say based on all the reasons provided in the recommended decision that we should approve the order as presented, and I would like to move that order.
I'll second.
You two are on a roll today. Michael, do you need to present the order?
Mr. Chairman, I don't think I need to. I think I'm in no disagreement with Anthony's recommendation.
Okay, terrific.
Mr. Chair?
So,
Mr.
yes,
Chair? I know I've thanked Anthony a dozen times, but Mr. Medeiros, thank you for all the hard work you put forth and all the solid, the presentations and everything you put into like I said, I've always trusted your skills and ability. So thank you. And if I don't get to see you because of all this COVID stuff, thank you for everything you've done to help me understand my job as well.
Terrific.
Thank you,
Michael.
Mr. Chairman, commissioners, Commissioner, thank you so much. Truly appreciate it. Mil gracias.
You're welcome.
Mr. Chairman,
Yes.
this is Commissioner Vicente Aguilar. I have a question for Anthony.
Sure, go
You went through the process of recommending your decision, including hearing examiner Ashley Schnauer. We've worked together on this case. I've requested public hearings through the process. I wanted my constituents to understand where PNM is coming from and where they are going. And I deliberately asked them to have public hearings in communities in Northwest New Mexico. And so that all my constituents can understand that the record is going to be available for them. Anything that is handle through the public hearing. I continue to verse my opinion regarding the Central Consolidated Schools and in reference to the property tax revenues over the next 20 years. And I have to say that I support your recommended decision. In reference to the solar bill out near the Central Consolidated Schools, and this will be immensely helpful for all the students that attend that school, and also for the community that have been planning. How do we support the schools once the San Juan generating station has been closed? So we continue to voice our opinion on that. And you heard us clear and well. The hearing examiners heard the community support that it needs to be continued to be supported the next 20 years. And the amount of money that's going to be allocated for that, I am very, very thankful for that. And I also like to say that our hearing examiners were firm when it comes to all the cost recovery and the rate treatment determinations that P&M would like to put on the record. It will be considered in future cases. It will be analyzed. It will be scrutinized. So I like to also support you and also thank you for putting that forth in your recommended decision. So that's my comments on this, and I'm ready to vote.
Thank you. Michael, you want to call the roll?
Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
Commissioner Espinoza. Let's skip Commissioner Vicente Aguilar.
Aye.
Commissioner Fishman.
Aye.
Going back, Commissioner Commissioner Espinoza.
Valerie, I'm here. Yes, sir. Aye.
Commissioners, the order in 20-00182 is approved by a vote of 5-0.
Ashley and Anthony, just like to compliment you on your extraordinary patience and thoroughness in this complicated endeavor. Just a terrific, terrific job that does the commission proud. So thank you very much.
Oh, wait a minute, Mr. Chair.
Yes.
It's Commissioner Espinosa. So
Yes.
sorry, Ashley, I left you out, and you too have been an immense help to me over the last 8 years. And so I thank you for allowing me to go to your office and sit there with you and talk about issues and talk about, things that I needed to comprehend. And you both helped me make my job so much easier. So thank you.
Well, thank you. It's been a pleasure working with you.
Same here. I won't forget you guys.
And just to let you know, Ashley's still on the hook for a few cases at the next meeting.
Oh, darn it. So, but what if I'm not?
Yeah. Just don't screw it up, Ashley, okay?
Quit teasing.
We're on to item 11, which is a matter of El Paso Electric's amended application for approval of its amended Renewable Energy Act plan and 2020 Renewable Energy Act plan. Christopher Ryan, please take it away.
Good morning, commissioners. So yes, this is EPE's amended application for approval of its 2019 and 2020 REA plans, which addresses EPE's RPS compliance for plan years 2020 and 2021. The case comes before the commission as a contested stipulation, and upon the certification of stipulation I authored on October 9th, 2020. That certification recommends that the contested stipulation be approved. The city of Las Cruces, the one party who opposed the stipulation, issued exceptions to the certification. The procedural history of the case is lengthy and involves EP's RPS plans for 2 years. For this presentation, I'll focus only on the core pieces of the background, just as a matter of time management. So initially, EPE sought approval to enter into the 2 PPAs to acquire solar power from Hecate 2 and Buena Vista 2, which is I refer to as H2 and VV2 for time saving. Temporarily reallocate to New Mexico solar generation produced at Macho Springs, and amend its RPS cost rider to capture expenses associated with the Macho Springs reallocation. There was unified pushback from the interveners on the Macho Springs plan. A few days before the scheduled hearing date in early August of this year, the parties alerted the hearing examiners that a stipulation was reached. The terms of that stipulation modified EPE's amended application in 3 crucial ways. EPE agreed to withdraw its request to reallocate energy from Macho Springs. And given that determination, EPE agreed it would no longer seek costs associated with the reallocation. And finally, EPE agreed that it would instead accept that it would have REC deficiencies in 2020 and 2021 and use excess RECs it anticipates generating beginning in 2022 and thereafter to retroactively make up the REC deficiencies. All parties but the city of Las Cruces agreed that this basic plan was preferable to the Macho Springs plan and should be embraced as the course forward. Specifically, the stipulating parties asked the commission to, in the certification or in the stipulation, they asked the commission to authorize EPE to enter into the H2 and VV2 PPAs, grant EPE a variance from RPS compliance for plan years 2020 and 2021, permit EPE to incur anticipated REC deficiencies in 2020 and 2021, and to make up those deficiencies with surplus RECs that they will begin accruing in 2022, approve EPE's reconciliation of RPS costs and revenues, approve EPE's 3rd revised rate rider number 38, and grant EPE additional variances from any regulation now inconsistent with the amended REA. So the question before the commission is whether the stipulation should be approved. As was laid out in the recommended decision I provided, there are 3 factors that guide the resolution of that question. The RD asserts that all 3 factors weigh in favor of approval. I'll go over those each as quickly as I can. So factor 1, opportunity to be heard. All the parties in this proceeding have notice and an opportunity to express their positions on the stipulation. This is all undisputed. Factor 2 is the whether the stipulation is in accordance with applicable law. Here, the focus is on the new sections of the REA that we have, sections 62.16.4, G1 through 4. So the first of those, G1, is cost questions. H2 and VV2 are undoubtedly cost effective, near record low levels. They are also essential to EPE's REC makeup plan. They're necessary for EPE to meet the 20% RPS standard governing through 2024, and essential to EPE prepares for compliance with the 40% standard that'll kick in 25. So the city's opposition is 2 cost-based arguments, and basically their position was the H2 and VV2 will be more costly than the stipulating parties represent due to the curtailments. And the second position the city took was that the plan is not cost-effective, that it is not going to ensure RPS compliance because DG REC overcounting will not allow EPE to meet compliance presently or moving forward. The certification and stipulation rejects both claims. On the curtailments question, the city's arguments were factually unpersuasive. EPE presented credible evidence that it will be able to minimize curtailments of H2 and VV2. The RD that I've prepared credits EPE's projection that it can operate in a fashion where no curtailments is a possibility. The DG REC issue, the city's argument about the DG RECs associated with energy consumed on site is also not grounds to reject the stipulation. Crucially, the city's argument that the DG REC issue will be a problem is really one concerned with future compliance. It is a problem now only in that the city believes EPE should be more aggressively planning resource procurements. Even if the city is correct about the DG REC issue, the concern is actually one that militates in favor of approving the contested stipulation, as rejecting H2 and VV2 would only compound the REC shortfall the city claims will happen. Ensuring the DG REC issue is correctly resolved with maximum input from all stakeholders would be affected by the resolution of the issues There's also grounds to decline and address the issue in this case. Broader input through the inquiry docket is a possibility, though based on the vote that just occurred, I'm guessing this will not happen. The issue can alternatively be addressed in a future RPS proceeding where careful briefing on the issue could be requested. The discussion that exists in the opinion, the recommended decision prepared for the commissioners is my attempt at really parsing out some very complicated arguments that required a bunch of work on my part. And my feeling is always the more input you can get, the better determination you have. So moving on to G2, the capital and operating expenses of EP's non-renewables. In the preceding calendar year, EP operated 5 non-renewable plants. The cost of H2 and BV2 are nearly half of EP's least costly non-renewable resource. As to subsection G3, this particular provision within the statute has 3 subparts. G3A looks to the competitiveness of the RFP. H2 and BV2 were selected from a procurement process where 69 proposals were submitted by 16 firms. EP employed an annual cost methodology to target projects responsive to present RPS requirements. EPE did this to take advantage of declining renewable energy project costs in the near term and to benefit from technological advancements that may come into existence in the near future. EPE's basic statement on this was that over procurement of resources at this juncture benefits no one. The city objected to EPE's use of the annual cost metric. They noted that the fact that EPE employed an annual cost, the analysis that I provide in the recommended decision to reject the arguments about the opposition to the annual cost metric include the fact that EPE employed an annual cost methodology in order to make sure that its long-term strategy for resource procurement was successful. The annual cost methodology necessarily involved a net present value analysis, which means that it comports with 17.9.572.13b. The amended REA states that the commission needs to consider both cost and overall cost. And the use of these 2 distinct words suggests some distinct analysis is required for each. So one way to think of how these 2 analyses might work is that the NPV metric is applied for cost as required by the regulation. And annual cost is employed as a metric to understand what the overall cost of the plan was. If the commission is unpersuaded and finds that the annual cost measure used by EPE is not compliant, then it should grant EPE a waiver of the NPV regulation, as EPE's decision to examine annual cost is certainly in ratepayers' best interests. The G3B factor is the cost of procurement as a comparative matter. As already stated, H2 and BV2 are very competitively priced. G3C is focused on the public interest. The statute makes clear the commission must consider both cost and economic development opportunities. As to cost, we've already described that there's a very low cost to these resources. With economic development opportunities, it appears clear the project's going to bring site maintenance, construction, and operation jobs. The city raises several public interest concerns. Primarily, the first one to consider is the SIRLEF question. So the city's position was that the rate rider calculation that EP utilized embraced a SIRLEF costs, and that the SIRLEF costs were included in that calculation. The recommended decision rejects the contention that SIRLEF costs need to be excluded. The state order arising from the city's appeal of the commission's decision to permit EPA to pay $30 per rec does not order EPE to stop collecting the SIRLEF costs. It just requires EPE not to pay those costs to SIRLEF. The commission could conclude that EPE should not collect costs if it is not presently obligated to pay them, but EPE presented a compelling argument why this was not the way forward. In fact, EPE contended that it's in EPE's customers' best interest to prevent a possibility where they might have to pay a large figure later on down the road. It's better to allow the status quo to continue and that to collect the payments. And if EPE fails to prevail at the Supreme Court of New Mexico, then they are happy to refund the money to the ratepayers. There was one aspect of SIRLEF costs that the recommended decision does determine was inappropriately included, and this includes a 30 per rec cost for recs in SIRLEF obtained in December of 2018. At that time, the price permitted was only 15 per rec, so there was a recalculation that's needed, and that's why the recommended decision or the certification of stipulation recommends that you have to send it back to them to recalculate. The other issue was the large customer cap question. It was clear that the large customer cap was employed even after it had been repealed. The evidence indicated that wasn't done purposefully. It was a confluence of events that just is what happened. There is no question that EPE applied the large cap after its repeal. This point is it's not clear what to do with it, however, as the city's own witness indicated that it will not have data to actually address what EPE large customers should have paid until the end of 2020, which is obviously in the next few months. So the question about the large customer cap and what to do with it should be addressed in EPE's 2021 compliance proceeding when data is available. The last issue of this particular factor is the overcollection from voluntary renewable energy program participants. Here, this is a speculative argument. The city brought this based on what they assumed to be happening, not on what actually did happen. This can be addressed in a future REA compliance case where the data actually exists to see what occurred. And then finally, the one other public interest concern the city raised had to do with symmetrical carrying costs. The city's position is that EPE's rate rider should involve penalties for over and under collection. In the under collection context, the ratepayers would pay interest. Where EPE over collects, it pays interest. So there's no reason to address this here, where the only question is whether the stipulation fee should be approved. It was a request that was a pure policy determination that really had no bearing on the ultimate stipulation itself. The question whether ratepayers and EPE should each carry cost is also one where input from ratepayers would be very valuable. That wasn't really present in this case because there was a stipulation which everyone agreed to that didn't get into this issue. So we actually don't know from the litigants who appeared in this case what the public's view about this question is. So if the commission is inclined to consider this proposal, it could do so in the inquiry docket, but again, it appears that that question won't be included. And also you might consider the fact that if there's going to be resolution that rate riders will not be used into the future, why would we do this at this juncture? The last aspect of the analysis is section G4, strategies to costs. And as I pointed out earlier, EPE's basic plan is to procure smaller targeted procurements, and EPE sees this as a way to benefit from continued cost reductions for renewable projects, and so that it can position itself to benefit from technological advancements. So for all these reasons, I argue in the certification of stipulation that the commission should find that the stipulation is fair, just, and reasonable in the public interest, and that the stipulation should be approved. Because EPE included one minor cost that should not have in its proposed rate rider, the rider must be rejected and recalculated. And with that, I'm happy to respond to any questions.
Questions from commissioners? Christopher, I'll just make a quick comment, is that the way you wrote your RD really made the issues quite clear. And I know it looks simple, but it's not. And that's a talent that you made it seem simpler maybe than it was in actual practice. So thank you for that.
I appreciate the compliment.
Michael, anything that you want to talk about on the proposed order? Or excuse me, Russell.
Good morning, Mr. Chairman, commissioners. I apologize, I was having some trouble with my laptop, but I have sent you the order, the proposed order, which was simply adopt the certification of stipulation. As the chairman said, Mr. Ryan did an excellent job on dealing with all of these issues. The exceptions that were filed to the certification of stipulation by the city were all issues that you've heard Mr. Ryan discussing. And they were all issues that were brought up in the post-hearing briefing. There was nothing new after the certification of stipulation. So the proposed order would simply adopt Mr. Ryan's reasoning, along with the reasoning of EPE's responses to the city's exceptions, which went along with that reasoning. I can discuss the exceptions in more detail, but you really have heard Mr. Ryan address all of them at this point. So like I said, the order would just adopt the certification of stipulation.
Motion or action from the commission?
So moved.
Valerie, you're still on a roll. I'll second.
I'll second.
Okay, I'm going to give that second to Commissioner Byrd.
You're all right.
And Michael, will you call the roll?
Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
I'm sorry, I didn't.
You're on mute.
Hi, can you hear me?
Yeah.
Yes, no, we can.
Ay, ay, ay.
Commissioner Espinoza,
Ay, ay, ay.
Commissioner Vicente Aguilar,
Aye.
and Commissioner Fishman.
Aye. And before we move on, just one comment I'd like to make is that the city's concerns around how RECs are accounted for is a valid one and doesn't affect, you handled it correctly in this case, I believe. And we just need to keep an eye on it as we go forward. And we look at our next resource acquisitions to be sure that we're conforming to the requirements of the EPA. But you outlined that issue beautifully and put it in the context that I think everyone can deal with going forward. So thanks for doing that.
Thank you, Commissioner Fishman. I agree with you.
Okay. So let's move on now to, God, are we on AV water? Yes, we are. Item 12, the matter of AV Water Company advice notice number 2. And we've got Elizabeth Hurst. Elizabeth?
Hello, Mr. Chairman. How are you?
I'm good. How are you today?
I'm okay.
Okay.
Good morning, Mr. Chair and Commissioners. Yes,
Good morning.
we are here today on a utility that is quite familiar, I'm sure, to a lot of the commissioners, and unfortunately not for in a good way. So hopefully today's recommendation is going to try to move things along in a positive manner. As the commission may recall, more than 5 years ago, this developer instituted water utility came to the commission, ultimately culminating in a recommendation that they get a CCN. That was approximately in first part of 2016 that the commission granted that. Unfortunately, it wasn't long until the commission heard from them again, partially because of the 2015 Gold King mine spill that allowed the pollutants to come into the river. And that was especially troublesome for a utility like AV Water, who instead of using well water, this is the first utility I had ever dealt with in my time with the commission that actually uses diverted river water from the San Juan and the Animas. So, of course, problems began. At that time, it was composed of 2 separate systems, the Morningstar system and the Harvest Gold system. As some of the commissioners may recall, the commission instituted a docket that culminated in $1 million fine, which AV Water never paid. And eventually the Harvest Gold system was taken over by a local system, and that left the Morningstar system, which serves the residents of Crouch Mesa. And this is a system that is approximately 1,875 customers outside of Farmington. And due to the mismanagement, poor condition of the system, and the fact that they had 2 huge loans, one for the water rights that they bought, and the other an operating loan. The first to Andrea Corp, the second to Stonetown Animas lenders. and their non-payment of those loans, they ended up in 11th District Court. And ultimately, the court appointed a receiver in 2017 to actually operate this system and try to preserve service. Since that time, the receiver, and the gentleman's name is Randall Lewis. And as you can see in my certification, I commend Mr. Lewis for his efforts to come in, and you can see primarily, I think, through pages 25 and through 27, where it sets forth the horrible situation that the utility was in when he took it over, the unpaid debts, not only to the aforementioned lenders who had filed collection, but they went from diverting their own water and treating it after the problem with the Gold King mine. They started buying water from the city of Farmington, and they owed the city of Farmington lots of money, and that wasn't being paid. And there were a lot of breaks, and he discovered a system that not only had owed a lot of money, but hadn't issued bills for 8 months. So they didn't have revenue coming in. And Mr. Lewis instituted steps to try to turn those things around, and has again, based on my review of the evidence presented in this matter, he's done a very admirable job. So he came in on a petition, and as you see, there have been a couple of cases. He had an initial one, and then he filed a second advice notice, and the commission just basically transferred those things and put them in the current case. And so I was given back in May this case, and it's a rate increase request. And basically, the request is for about $413,000 revenue request. As it was originally posed, there were two components of the rates. The first being the customer charge, which in the initial filing they had proposed to increase, and then they were also going to increase the commodity charge or usage charge, and that's very typical, as the commission knows, in rate cases. And then what happened was that the commission assigned a mediator, Ms. Glick, to try to mediate the case. She worked diligently to do that, and ultimately, working with the commission's utility division staff, Mr. Lewis, and 4 of the 6 interveners that we had in this case, 4 of the 6 pro se interveners. We had a Karen Northup, her husband Sky Northup, Tiffany Birmingham, Kaylee Groth, were all participants that actively participated. We also had interveners John Bryce Haskell and Rebecca Brianne Salazar Haskell, who are interveners but didn't participate in the stipulation, along with our intervener, Stonetown Animus Lender, which, as you know, is somebody that AV Water owes money to. So ultimately, what came to you in the stipulation was a different way to collect that $413,000. And so basically what the stipulation set forth was that the base rate not change. So your customer charge, or your base charge not change, your customer charge, that those all stay the same, that there be a change in your commodity rate. And as the commission knows, as it's done in other cases, when the commission's trying to encourage ratepayers to utilize less of the product, especially water, we make it more expensive the more you use, and that's what this does. But the other important thing about the usage charges, the commodity charge, is that the way that they were that they're currently structured now, they don't collect the cost to buy the water from the city of Farmington. Again, as I have told you this morning, it used to be because they treated their own water and diverted it and treated it, and that was those rates were set up based on that. That's not the case anymore. They purchase their water from the city of Farmington, and that initial dollar for 3,000 gallons didn't pay the city of Farmington. So that needed to be corrected, and that's part of what the increase in these usage charges. Okay, so no increase in the customer charge. Approximately 23% of the increase would come from the usage charges, but the majority of the increase that AV Water ratepayers would be paying, and it would be paid equally by every single customer. So they have 3 different types of customer classes. They have residential, commercial, and what they call a multifamily, which is more than one unit that is served from one line. Each and every one of those customers would pay what they named as a repair and replacement charge. So basically, the evidence was presented that the majority, other than operation and water costs that were being expended, were to try to repair some of the just really bad operational characteristics, like the wrong grade of pipe being used, and some of the fixes were duct tape and different. And you know, I'm the daughter of a carpenter. I realize there are uses for duct tape. I don't believe that a public utility fixing a leak is one of them. But the parties agreed that this repair and replacement option, this rate, was acceptable because it was going to transparently give money to the part of the operation that needed it most, and that was the actual provision of the service. And additionally, Ms. Karen Northup, as I've indicated to you, was one of the interveners who helped, participated and helped negotiate the stipulation. I allowed her to provide testimony in the case, and she indicated to me that
Commissioner Espinosa, you want
Yes,
to break
ma'am.
it for a second?
Yeah, I just wondered, you were talking about the interveners helping with the settlement. Are you telling me that they were in agreement with the amount proposed of the increase?
Mr. Chair, Commissioner Espinoza, yes, ma'am. The 4 of the 6 pro se intervener, and also then the non-pro se who was represented Stonetown, all are in agreement. This is they call it an uncontested stipulation. I can tell you it's not opposed. the two interveners who didn't sign off on it didn't oppose it. So yes, they are in agreement. I can also tell you that since I've had this case, I am only aware of I believe two public comments that were filed, and one was just providing information from Ms. Browning, and then there was also a gentleman who did file an opposition that he opposed the rate increase.
Well, yeah, okay. First of all, I just want to say that I really appreciate how you went into the gory details, the facts, the truth of the matter of this case, and how difficult it has been for them. I remember this case extremely well, the mud pouring out of their faucets. I remember not just the duct tape, but the pieces of wood stuck in the tank. And so I guess my question was definitely related to the interveners and their participation in the settlement. But there were many things wrong with this case from way before you took it over, and there was a ton of mismanagement and in some instances a lack of due diligence and of former people that have worked on it. Anyhow, this has been, and again, I appreciate you pointing out the hardship, and I'll let you finish, but definitely it has been a horrible situation, but we knew that the outcome was going to head in this direction. So again, I just wanted to thank you for pointing out the actual gory details of this case. And so, yeah, please continue. And I know I'll have more to say. So thank you, Elizabeth and Mr. Chair.
Mr. Chair, Commissioner Espinoza, thank you. Thank you so much. And it was an excellent segue, actually, to me sort of getting to the happier part of what could be in their future, and understand that that I realize that every customer paying $14.10 more on their bill, and some more, potentially depending on how much they use, could be significant to someone, especially someone on a fixed income. And I didn't take that lightly when I considered this, but I also considered the fact that people were not paying for the water that they were using, and that something positive has to happen to make this utility work, or there's not going to be a utility, and people will have to provision their own water, and I don't think that's a viable alternative. So I have recommended to you that you approve the stipulation. It will allow them to operate. It will allow them to continue to make repairs in the same, hopefully in the same amount, a little over $300,000. It will allow them to pay some money. They're not going to be able to make their full debt payments, but they'll be able to pay for their water to the city of Farmington. They'll be able to hopefully pay at least part of the interest on the money that's owed to the lenders. And then finally, hopefully it's going to make them more attractive to be sold. And that's the ultimate goal of the receiver. And I can report to you, I haven't seen it because I don't know the details because it's sealed. But I have been informed that there is an offer in the receiver case. And when last I heard, the court hadn't made a decision. I haven't been updated on that. And I know at one point the court was waiting to see what the commission did in this certification case. But the offer.
Do you know if those are? So I'm sorry, Mr. Chair, and
Go ahead, Commissioner.
thank you. So are you saying that this information that you're saying about the receiver and the potential for purchase is something that's really on the table, or is it just hearsay, or what's the status of the court procedure, or whatever you're referring to?
Okay, and Mr. Chair, Commissioner Espinosa, if you look at my footnote on page 25, and it's footnote 53.
Don't make me look at my tiny little phone.
Okay, let me read it to you. Okay.
Yes, please.
The hearing examiner was informed by the general counsel's office that there was a motion to approve asset and real property purchase and sale agreement had been filed with the 11th Judicial Court. The sale provides for the sale of the property to an actual regulated utility, New Mexico Water Service Company, which I believe is a company that we've dealt with here at the
Sounds
commission
familiar.
before.
Yeah, I do remember. Mm-hmm.
And the only other term I know of that was publicly disclosed that I could see, because I'm not part of that proceeding. Mr. Fisk might be able to tell you more since he's your counsel in that proceeding, but it was for a price of $4.5 million. And the only information I got on that is that I believe that the money would go to the creditors. It's not going to go to Mr. Upenlatz or anybody from AV Water.
Wow, that's another name that I remember well. Russell, were you going to say something about that in response to Elizabeth's request?
Yes, Commissioner Espinosa, and Mr. Chairman, Commissioners. So as I noted in my memo, yes, there's, as you know, there's a pending receivership action. That is the action in which in Aztec in district court, in which the receiver was appointed years ago. And in that action, there's a controlling order that describes how in the event that the receiver found a potential purchaser, that the purchase would first have to be approved by the court under the receivership law, and then would come to the commission for review on an application for transfer after that. So we shouldn't discuss, we certainly don't want to discuss any of the potential merits or demerits of any such application, because that will presumably be coming before the commission. With regard to
but
where
it won't be coming. Yeah, go ahead.
With regard to where it stands with the court, yes, as Elizabeth said, the court, the parties to the potential agreement wanted to wait and see what happened with this rate case before asking the court to actually rule upon the motion for approval of the sale. So that hearing was originally set, I think, in September. It's been continued, I think, to sometime this month or in January. So that's where that stands.
Yeah, okay, that's good information, because I know these residents have persevered, and I know they've been through a lot, and I don't want them to have to wake up to another nightmare. So that's why I'm asking these questions, and so I appreciate that information from both of you. Thank you, Mr. Chair.
Thank
Go
you.
ahead.
Thank you, Mr. Chair and Commissioner Espinosa, for your inquiry. That was going to be my last point of, again, hopefully a better 2021, utility that was going to actually start paying its bills and then have potentially an an actual utility run them could be in their future. And with that, that's pretty much all the information I wanted to tell the commission. And if the commission has any other questions, hopefully I can address those. Thank you.
Questions from commissioners?
Yes, Mr. Chairman, this is Commissioner Vicente Aguilar.
Go ahead, Commissioner.
And I'd like to thank mediator, hearing examiner Glick, and also hearing examiner Elizabeth Hurst. As you all know, that the conditions were like boiling water for about a year and a half, and it affected one or two water systems operated by AV Water within the last few years, which was transferred to a mutual domestic water customers association at one point. And I support the stipulation. It provides for an overall 27% rate increase. And I also support the stipulation because it recognizes the importance of the potential sale of the system. And hearing examiner Hurst, your recommendation, I see that it's uncontested and it's in the public interest and resulting in fair and just and reasonable rates. And I'm looking forward to the new company taking over at some point, and I'm willing to continue to work with my constituents to make sure that their charges are going to be reasonable. I know that the certain single family residential, there's going to be an increase, and there's also it's going to also affect our multifamily residential, commercial and industrial and other changes. But I'm looking forward to a positive resolution on this AV Water scenario for quite a few years. Thank you very much, Commissioner Hurst, and thank you very much, Mr. Chairman.
Any other commissioner questions or comments? Russell, would you like to present anything that we need to know on the order that hasn't been covered?
Mr. Chairman, I don't have anything to add. The order would just adopt the certification of stipulation.
Terrific. Any motion? Well, I'll move the order.
I'll second.
I'll second that.
Thank you, Commissioner Vicente Aguilar. And Michael, if there's no further discussion, Michael, would you take the roll?
Commissioner Byrd,
Aye.
Commissioner Hall,
Did
Commissioner,
you hear me? Can you hear me?
we can now.
Okay, aye.
Commissioner Espinoza,
I'm going to vote no because, I want to explain that I am still leery and skeptical, and only time will tell. And these residents have been through enough already. And so I cannot support a 27% hit to anyone's pocketbook. I have way too much compassion for those people regardless. They've been promised resolution to issue after issue related to their water, and I vote no.
Commissioner Vicente Aguilar,
Aye.
and Commissioner Fishman.
Aye.
Commissioners, the order approving the certification of stipulation is approved by a vote of 4-1.
Thank you, Elizabeth, for that great presentation. And
Yes, sir.
nice to see progress being made, and you and hearing examiner Glick helping move the ball forward.
Thank you, sir.
Yeah, and before we move on, I just want to acknowledge Commissioner Espinoza's point is, boy, it's been a nightmare for these folks. I wish there was a way we could do it that wasn't nearly as expensive as this is turning out to be. Their water bills are not cheap, but
Right.
at least they're getting water. And boy, life without water is pretty tough. So
Right. Yes, I appreciate your comments, because had you been living through it while I was there, I did see an awful lot, and I did see, like I mentioned, the mud coming out of their faucets for not only the elderly, just the pets, the animals, there was not just people that were impacted by the filth. There were sick people that suffered because they couldn't even, bathe or bathe in that water after they got out of the hospital. So I think, to the detriment of some of the people you mentioned, I think it was terrible what they had to go through, and what the developer put those people through. And so I have no faith in what happened to them. I just can't imagine. So I just won't forget that case, and I sympathize with those people, and always will remember what they had to go through. And I don't see things getting any better by changing hands. So anyhow, thank you, Mr. Chair, for your comments.
yeah, and let's hope that in this case that you're mistaken in what's going to happen, and that the 4 more optimistic commissioners on this one luck out, and this turns out to be a good decision, and they find a buyer who can make the system work. So,
well, I'll be waiting to hear you tell me that I told you so, but I'll be waiting for that call in about 2 years.
okay.
Thank you.
I'll be calling you.
Yeah.
Good. I'm glad, because I think there won't be a commission in 2 years, right?
Well, they'll be appointed.
That
Okay.
was supposed to be a joke, and you didn't think it was funny.
Yeah. Okay, on to fire marshal matters. In the matter of rulemaking, amending rules pertaining to fire and smoke dampers pursuant to section 59A 15.1. And Hans, you've got this, and you've been very patient with my impatience on the dampers, so thank you.
I appreciate that, Chairman Fishman. And as I noted in my memo to you, I am rather using this as a placeholder to bring the commission up to date on where we stand and seek further guidance from you as to how you would like me to proceed with this. The commission's order issuing the NOPRA initiating the rulemaking document on June 24th, 2020, with the proposed rule drafted by this fire marshal's office staff. The order set the comment schedule with comments by any interested persons due by August 31st and response comments due by September 14th. The commission received 8 comments by the deadline and 3 response comments by the response deadline. A public hearing was held on October 21st, 2020 that I presided over, at which 32 interested persons made comments regarding the proposed language. The record was then closed on November 7th. And I'd like to note that after the record was closed on November 7th, 2 motions were filed into the record by Construction Industries Division, a motion to intervene and a motion to reconsider the commission's prior termination of rulemaking. Even though both were ultimately filed after the record was closed on November 7th, I feel it's worth noting that essentially rulemaking proceedings do not have parties, so to speak, that there is no need to intervene. And any member of the public, including agencies such as SID, may file comments in the rulemaking record and make oral comments at hearings, so no intervention is really necessary for such purposes. In regards to the motion to reconsider the termination of rulemaking, I still feel, as we discussed at the prior decision, that it is premature at this point to terminate the rulemaking. We still have quite a bit of time, before the fire marshals leave the PRC, which is actually the earlier deadline between that and the NOPR deadline of 2 years from publication. So I still feel it is premature there. However, at this point, I would like to inform the commission, as I did in my memo, that I feel I've identified a couple of sticking points with the current proposed language as is. And I would like the opportunity to review that more with parties to essentially reopen the record to allow for additional commentary specific to questions that I would draft regarding the sticking points that I've identified. I think in doing so, we would allow Sid and other interested parties the additional time to respond and make the comments that they would like to make, and I would like to get extra feedback from them at this point prior to proceeding.
Just Hans, just real quickly to clarify, Sid is the Construction Industries Division.
That's correct. CID. I'm sorry. With the commission's permission, I would ultimately like a motion to reopen the record for approximately 1 month. I can bring a proposed order denying the motion for intervention and reconsideration of termination of rulemaking. And once the comment period is reopened, I can draft an order encouraging additional responses from staff and interested parties, particularly to specific questions regarding the term installation as it currently stands in the proposed language. I think I have identified a couple of sticking points that can be resolved to make a resolution. So I would ask the commission at this time, allow the record to be reopened. And I have reason to believe that Chief of Staff would support that record being reopened at the but I'll stand for questions from the commission if you would like me to proceed in another manner.
Mr. Chair, I couldn't agree with Council more than, so I'd like to, I know you said you don't have an order prepared, but I'd like to motion to reopen the record for public comment. And I think that's in our best interest because of the agency moving over to Homeland Security in the first place. Another thing is the new role that Representative Winnie Stewart has taken at the legislature had mentioned that it was never her intent to proceed the way we have been, and she testified before the commission. So I think we need to open up the public comment portion again. So I'm making a motion to reopen the record as recommended.
Thank you, Commissioner.
Second that.
Thank you.
So we have a motion from Commissioner Espinosa, a second from Cynthia, from Commissioner Hall. And any discussion from commissioners? Okay, Michael, let's go to a vote.
Commissioner Byrd,
Thinking about it.
I heard that.
I guess. Yeah, I'll abstain.
Next.
Commissioner Hall,
Aye.
Commissioner Espinoza,
Aye.
Commissioner Vicente, Commissioner Vicente Aguilar,
Aye.
and Commissioner Fishman.
I'm going to agree with the aye vote. I just want this one to end.
Right. Thank you.
Aye. Okay.
Thank you, commissioners.
Thank you. Love it.
Good luck on getting this one resolved. Thank you.
Thank you.
So Michael, you got the vote there?
Yes, that's a vote of 4 and 1 abstention. 4 in favor, so the vote. The order passes.
And Commissioner Byrd, boy, do I sympathize with your abstention. Oh boy. Anyway, let's go on to discussion and potential action. Resolution 12-2-20. Resolution to set commission requirements of the ambulance annual service report. And Jason or Judith, whichever.
Sure, either one. Judy, go ahead. I'll give you
No,
the.
I'll allow you, Jason, to go. I worked on the formatting, but Jason probably is better suited to describe the need.
Yes, thank you, Mr. Chairman and commissioners. I believe you've been given a copy of the proposed resolution, and we just wanted to give staff an opportunity to collect information and data that we believe will be useful as we continue to evaluate ambulance services' responsibility of providing safe, continuous, and adequate service. And looking at the typical information we get on the annual reports, I have discussed with staff on several occasions, and we've come up with these bullet points in the resolution, which I'd be happy to read if necessary. But I also want to mention that I did share this resolution, at least the bullet point portion, with a partner from the Department of Health EMS Bureau. The EMS Bureau's responsibilities overlaps the PRC per se, not in the regulatory realm of things, but they definitely are involved in ensuring safe and reliable ambulance service throughout the state of New Mexico. So they are involved, obviously, with what's happening in that industry and who's doing what and where. And we have just come to a conclusion that we believe other information that should be made readily available from ambulance services should be provided, that we would be allowed to at least assess the annual reports in more detail on an annual basis. If you remember, also the ambulance inspections are required by statute annually. And so if we can at least continue to work with our economists in transportation and our inspectors and investigators to look at information that has been added to the annual report form in this resolution, we just think that it would give us a better opportunity to assess situations throughout the whole state of New Mexico, and possibly come before the commission and make recommendations, or even the legislature for that matter, on funding opportunities for rural New Mexico. Those are just a couple of examples that have come up in our discussions. And so with that, Mr. Chairman, I guess I'll stand for questions unless we find it necessary for the resolution to be read.
Commissioners, questions?
I would say just read it for the record, and I support it.
Sure, will do. New Mexico Public Regulation Commission, a resolution 12-2-20, a resolution to set requirements of the ambulance annual service report. Whereas the New Mexico Public Regulation Commission has identified a need for additional information from certificated ambulance service motor carriers in its EMS Bureau annual service report that is prepared each year in accordance with the Transportation Division's motor carrier rules, ambulance 18.3.14.22 of the New Mexico Administrative Code. And whereas the commission has determined that pursuant to rule 18.3.14.22.f New Mexico Administrative Code, the commission has the authority to require additional information to be provided by certificated ambulance service motor carriers. And whereas the commission, after due consideration of input from the Transportation Division, has determined that it is in the public interest and promotes administrative efficiency for certain additional information to be provided by certificated ambulance service motor carriers in its EMS Bureau annual service report for comprehensive compliance, monitoring, and regulatory oversight. Therefore, be it resolved that the commission shall immediately require the following information be included by each certificated ambulance service motor carrier in its EMS Bureau annual service report, starting with the January 15th, 2021 annual service report for the preceding year. Name of the certificate holder and the NMPRC number, name of leasee if applicable, mutual aid plans or agreements per 18.3.14.9 New Mexico Administrative Code, counties authorized to operate in, number of runs completed per county authorized to operate in pursuant to 18.3.14.24 New Mexico Administrative Code, number of ambulance accidents to ensure compliance of 18.3.7.11 New Mexico Administrative Code, copy of the carrier's hours of service policy per 18.3.4.10 C New Mexico Administrative Code, random drug testing information per 18.3.4.10 New Mexico Administrative Code, and medical director and training coordinator information per 18.3.14.11 New Mexico Administrative Code. The commission shall provide notice of this resolution to all certificated ambulance service motor carriers at the address filed with the Transportation Division by email, or if no email, postal service address. Issued under the seal of the commission at Santa Fe, New Mexico, this second day of December 2020, New Mexico Public Regulation Commission, and their signature lines from each commissioner thereafter.
Thank you. Thank you for reading that. Isn't there already an applicable drug, the random drug test?
That is what is required of the motor carriers and the ambulance services themselves. What we're asking for, go back to that bullet point for you, is the random drug testing information pursuant to the rule. And if you'd like for me to go to that rule, I can, Commissioner Espinoza.
No, that's fine. I just thank you so much for doing that. You pretty much covered everything. So thank you, Mr. Chair and Chief Staff.
Thank you.
I'll move the
Chairman
resolution
Fisher.
if that's, you'd like that.
Let's go to Commissioner Byrd here real quick.
I have a question and still have heartburn over the issue. The number of runs completed per county authorized to operate in. What about the number of runs that happen in outside of those counties? Wouldn't that be information that is useful?
Well, I think my response to that is there shouldn't be any runs outside of the counties they're not authorized to be functioning in. So
let's do a hypothetical, but because I know it happens. We have a limited number of ambulances here in Quake County, and there have been times that we've called a neighboring county to send an ambulance because the time for them to get to Lubbock, Albuquerque, or Amarillo and back is longer than it is for the neighboring county to arrive, pick up a passenger, and take them where necessary. And if we could see the amount of traffic that is going on, maybe people will start to take initiative to get rid of these limited by county license and give a statewide license. And so that information would be useful.
Commissioner Byrd, they may be doing some of those runs pursuant to mutual aid agreements, and that's one of the items that has been added to this list. So you might want to ask number of runs done pursuant to mutual aid agreements, which are authorized by the rule.
Okay. How hard would it be to add that in there?
Jason, is there a recommendation or Commissioner Byrd on a change in language there?
Well, I think that's a good point that Commissioner Byrd brings up. And so we could add another bullet point that requests the number of runs completed pursuant to mutual aid plans / agreements, rather than outside of a county authorized to operate in. The reason
Right.
is if people are reporting that they're completing runs outside of their county, then by default, they're admitting fault and subject to potential enforcement action, right? So we typically investigate.
Which would be stupid on our part to say you can't go pick up somebody because you don't have authorization, right?
I understand. Yeah, I totally agree and have heard the concern of being restricted by counties on several occasions.
Is there it should be a relatively straightforward process to engage in a mutual aid agreement. That shouldn't be, I wouldn't think, a complicated thing to accomplish, so that carriers have the freedom to make the kind of arrangements that Commissioner Byrd has raised. Is there any obstacle to that?
No, I mean, not very many people have mutual aid agreements. I don't have that number right here before me, but again, I think Commissioner Byrd makes a very good point. So if we want to use that to assess situations of lifting the restriction, obviously I believe that's going to be a statutory requirement, but it at least helps justify the need.
Or perhaps without needing legislation, you could create more of a blanket mutual aid agreement that people can sign on to.
Well, not all carriers have a mutual aid agreement. They're not necessarily required to. It's part of a negotiation between the ambulance service and a municipality or a county, typically that is in need and reaches out to a certificated ambulance service.
Okay, I'm just throwing out other potential ways to address the issue. But I'll leave it at that.
Mr. Chairman?
Yes, go ahead.
I think this is a very good discussion. This is something that we should look into. Maybe Judy or someone from the General Counsel's office can look into it further to get some policies in place when there's an emergency. Definitely, someone cannot just stop at a county line and say, I cannot help. So I think this is a new policy that we should adopt. And we need further clarification from General Counsel's office. What is the, what procedures do we need to follow going forward?
Yes, that would require research, definitely, to see whether the Motor Carrier Act would need to be amended to allow non-municipalities and non-counties to enter into mutual aid agreements.
Mr. Chair.
I would appreciate
that. Commissioner Hall.
You know, I prefer actually the original question that Commissioner Byrd put forward, which is just how many runs are made that are not within their county, regardless whether they're under a mutual aid agreement or not, because we want to discover, it seems to me, whether or not those types of runs are numerous or not, and under, you know, how frequently are the drivers forced to do this because of, you know, the emergency nature of their work or not. And to me, whether or not a mutual agreement is in place is not relevant to the kind of information we're trying to get. If there's a mutual aid agreement in place, that's good. But nevertheless, what we want to know is how big of a problem is it that ambulances have to go beyond their county or beyond their territory, or however we want to define that.
No, Mr. Chairman, if I may,
we need more information rather than less.
Yeah, that's exactly the issue. The the stopping and requirement of being restricted to a county line happens frequently, and I believe it's a statewide issue, especially during an emergency or non-emergency interfacility type transport. So definitely an issue. I just want to be careful that we're not going down a slippery slope on what we're asking for, because we are literally then having people self-report violating the current statutes and rules. And then we put staff in a situation of, well, what do they do? Are they supposed to then, take an enforcement action? I would rather not. I think we need to be open-minded about this realistic situation. And therefore I would ask that we have run reports submitted per their mutual aid agreements, which would include outside of the certificated territory and counties that Commissioner Byrd is referencing. I think we could work with the EMS Bureau and address the bigger issue in a different manner than what we're just trying to collect and start assessing and looking at prior to conducting annual ambulance service inspections. At least we have some information before we go to the yard and what the conditions are is what we're currently trying to achieve. But there is a bigger picture issue that all the commissioners have brought to the table today.
Jason, I have to say, I tend to agree with Commissioner Hall on this one and Commissioner Byrd, and that it would be nice, and I don't think it's part of this resolution, quite honestly, but if we want to get that information, we need to say this is self-reporting and there will not be, you will not be facing punishment. This is us trying to address an issue where our regulations have put you in a box, and we're not going to punish you for looking out for the public safety by breaking a rule now and again.
I agree with you.
Because we put you in this spot in the first place.
Yes, Mr. Chairman, I'm a huge advocate of that. In fact, there's something similar in pipeline safety that we've implemented, and it is, pipeline operators, as an example, are supposed to periodically review their procedures and their performances of their employees and tasks. And if they find an issue, they're supposed to take corrective action on their own behalf. And if they self-report that to our office, there really shouldn't be any consequences. The process worked, right? I mean, that's the whole reason for it to be in place. So I would agree with you. I just, when we're reading black and white statutes and rules, it can be complicated to deal with. But I also would agree that with the commissioners and would ask that we could address it outside of a resolution of collecting information maybe, or if there's a particular bullet point that we could put in here, and maybe there's a disclaimer paragraph that needs to be added to that point.
Yeah, and maybe, Brad or General Counsel, either one can kind of help you navigate the legal, the legal obstacles there, and create a situation where we're partnering with these ambulance providers to help them improve their service.
How about I work on some language and bring it back to the commission?
That'd be terrific, and I think we can do it outside this resolution. Is that how you see it, Jason? Or
I was going to ask if I could revisit the resolution and look for language that can be added to address the concerns that have been raised.
Okay. So on this resolution, is the idea to come back next meeting and see what you came up with on that adjustment?
Yes, Mr. Chairman, that would be my request.
Okay, and the commission, or I guess we should.
You can
Do we
table.
need to take a vote on that, Judy?
You can just vote to table the matter till next meeting.
Okay.
So someone would make a motion, and then you would.
I can withdraw my motion that I had made earlier.
Okay,
Or move
so
to table till next week.
There you go.
And I'll
And
second.
second, Commissioner Byrd?
I'll second. Yeah.
Okay, terrific. Let's take the roll on that.
Commissioner
Thank
Byrd.
you, Commissioner Espinoza. Aye.
You're welcome.
Commissioner Hall. Commissioner Espinoza.
Aye, as I stuff myself with a tamale.
Commissioner Vicente Aguilar.
You bring it up,
Aye.
everybody?
And Commissioner
Yes.
Fish.
Aye.
The resolution is tabled by a vote of 5-0.
Thank you, Commissioner Byrd, for bringing up that issue.
You're welcome. Thank you, Jason, for working with us.
Absolutely.
Yes.
And item 13, legislative policy. Jason, can you put that up on the screen?
Yes, sir. Give me 1 second.
We
here.
got there were some final adjustments to what I sent out earlier. I guess it was last week. Commissioner Hall had a
Commissioner?
great, let me finish
Chairman?
this thought. Commissioner
Sure.
Hall had some great clarifying little edits that she put in that I included in this copy. So that's where we are. Commissioners, comments, thoughts? How do you want to proceed?
I've got a question now.
Go ahead, Commissioner Byrd.
If I understood Miss Amir correctly, this deal with ambulances is a legislative matter. Maybe we can put that on our to-do list here to see if we can get those restrictions changed.
I think that's absolutely appropriate. I don't think, Judith, have we determined that it's a legislative matter yet, or we need to do more research?
Thank you, Commissioner Byrd and Commissioner Fishman. It's my understanding, just off the top of my head, that the statute might need to be changed, but you're right. I would need to read over the whole statute and the mutual aid agreement statute to make a complete legal determination on that.
So I guess, go ahead, Commissioner Byrd.
No, okay, that was it.
So it seems to me we should just put that, that's on the bench or on the waiting list to add if it turns out to be a legislative problem to address.
And Mr. Chairman, I'll try to respond. Judy, the correct citation is 65-2A-8F is the language regarding territory.
Yep. So it just sounds like, Jason, whatever kind of potential solutions you come up with will dictate how we add it or don't add it to these policy recommendations.
Yes, sir. I'll follow up with Judy. Thank you.
Okay, thank you. Commissioner Byrd, does that cover it for you?
Yes, sir. On that issue, excuse me.
Okay, terrific. That we can just take, if we want, we can just take 5 minutes, let people read through it, and then make any comments. And then I can go to the bathroom.
Mr. Chair? Mr. Chair?
Yeah.
That's too much information.
I just wanted to mention that the way this appears on my computer screen, you don't see any of the colored edits. Is that what was intended?
No, I didn't do that. I figured that would be more confusing, and these are short enough and sweet enough that people could just take a read. I know Joe Maestas was on earlier. I don't know if he's still there, but Jason, if you could make it him available to make comments on this, that's fine as well.
Yes, Mr. Chairman, I believe I did see Commissioner-elect Maestas on earlier. Not sure if he's still with us, but he could press *6 to unmute himself if needed.
Okay. And while you're eating your tamale, Commissioner Espinosa,
Yes.
and reading this, I'll take care of personal business and be right back.
Yeah. Yeah. Make sure you mention personal business.
There you go.
Not what you got to do.
There you go.
All right.
Close the door.
So for the other commissioners, you can see my screen and you'd like for me to scroll up or down.
Hey, Chief, this is Jeff.
Yes, sir.
Go to item number 3B, which is under the agency funding administration, number 3.
Okay.
Expanding the sources of education credits, it mentions utility accounting and law. I would also like to put in there professional engineering credits that PEs have to take for their licensure as to be applicable as well in that language.
Actually, Commissioner
So
Byrd,
everybody's looking at that.
Commissioner Byrd, I think that is already covered by the statute.
Oh, see, there are some smart people. They knew PEs were good. All right, thanks, Mike.
Sure.
He's an attorney, not a PE. You are the PE.
Technically, no.
Oh, so we won't talk about it publicly. You want a tamale, Jeff?
They smell very good.
Yes, please.
I found a really good place, and they are heavenly.
I found it to not be very filling, though.
That's why I'm heading my second one now.
I could probably eat 10 of these. It's not doing me any good.
It's Christmas. You can do whatever you want, but eat 12.
Yeah, my wife said I could eat all I want of these.
So you don't share?
Yeah, you can have all you want too. There you go.
Okay, I'm back.
Yay.
Yay.
Ay, ay, ay.
And it all came out all right. So there you go.
God, I'm eating.
I just had to do that,
That's been-
Valerie.
Oh,
It's got to be getting time to end this meeting.
Yeah.
one more meeting. Well, that's all I got. One more meeting.
This meeting will be censored.
I think I'm good with this that you presented, Chairman Fishman.
Ditto.
Any other commissioner comments on the content?
Ditto. Good
I
work.
had a little heartburn on one,
Oh, okay.
but it's not. It depends on how the bill's actually written. Number 7 in the first go around, number 7, and it just depends on the bill. You know that it's got to be specific timeline and stuff like that, or because it could be a open-ended.
Yeah.
Here, we'll pay your bill from now on problem.
No, yeah, but that's just a general direction. It's not trying to write.
Yeah, absolutely.
Just saying. let's
I'm
look at
not asking to nix it. I'm just saying that, you know, I could in the future.
Yep. If it's the wrong bill, and
Yeah, that's all right. And
But
that
I
probably
think-
goes for any of these.
yeah, I think the idea here is not to support a bill. It's just to support a policy direction.
General policy, absolutely. So I'm good with it if everybody else is happy.
Mr. Chairman, if now is the appropriate time, do you want to explain the next step?
Mr. Chair.
Yeah, I basically, I think we just want agreement on who we send this to
Mr. Chair,
and what we want them to do with it.
Mr. Chair.
Yeah, go ahead, Cynthia.
Hi, I wasn't sure if you could hear me. I just had a question about the agency funding and administration part, item number 2. Says establish an advisory support staff to provide research and technical support to commissioners. Do we want to say policy and technical support or policy research and technical support? It seems like it might be a good idea to have policy in there somewhere.
That works for me. Any objections to that from other commissioners?
It's just a tomato.
I have no idea what that means.
Tomato, tomato, whatever.
Yeah, policy research and technical support.
Just went right over my head. You're just too sophisticated for me, Commissioner Byrd.
So I would propose putting it in before research.
Yeah, let's just add policy there. That's fine.
You could say policy and technical research and support. Maybe that's more broad. Research and support, yeah. Thank you.
Okay. My thought was that this should go to legislative leadership, to the appropriate person in the governor's office. And do folks have any other thoughts where this should go? Or any objections to those two places? We're tired.
Maybe just every legislator, as you know, not just committees, but individually.
I agree. I agree with that.
Okay. Other commissioners, are you okay with that?
I mentioned I was good with it, and thank you for the effort you put forth in all of it.
And
Mr. Chair.
Yes, go
Mr.
ahead.
Chair, I'm in support of it. Thank you.
Okay. And you're okay with it going to all legislators, Commissioner Bissett?
Yes, absolutely. Yes, absolutely.
Okay.
What about the governor's office?
Yes, that is well. Jason, do you have a recommendation who in the governor's office to send it to?
Yeah, I'll have a couple that people there in their office that we can forward the information over to after we, I guess, put a really nice cover letter to it.
There, Mr. Chair, there's also, several state agencies that may have an interest in this, like energy and minerals or economic development.
Yeah, I think energy and minerals certainly make sense.
Yeah.
And economic development, I'm not quite as sure, but I don't think it hurts.
Yeah.
Any other thoughts on where this should go?
What about just posting it on the website, but expand it with explanation on each bullet point and what the benefit to the agency is, or foreseeable benefit?
So
and just have it there as a document.
Other commissioners' comments on that?
Or, yeah, a benefit to the agency or to the public from our perspective.
Anyone?
Well, on our website, available to the public.
Yeah. Does anyone object to that idea? Okay, so that sounds like a good one, expanded version on the website. Okay, Jason, is that
Yes, sir.
give you enough to work with?
Yeah, I believe so. I have the final comment made on this last item, and sounds like we have full commission support, so that's good to hear.
Thanks, everybody. We got a lot of good ideas and for me, unexpected ones. So thank you. It was great.
Good initiative.
So do we need to take a vote on this? Legal Beagles, tell us what to do. Hello?
Mr. Chairman, is that a request? Are you asking if you need to vote?
Yeah, do we need to vote on saying that we adopt this and who we want to distribute it to?
Not necessarily.
Yeah, I'm not sure that I don't know that you actually need a vote on this. I mean, if you want to have it reduced to the form of a letter that's going to be sent out to the various entities that you're discussing, and you want to present it at the next meeting or something, that might be appropriate. But I don't think that you actually need a formal vote.
Okay. So Jason, I guess just move ahead with the list of people to send it to, and I guess we'll draft a cover letter to send it out.
Yes, sir. I can do that, Mr. Chairman.
We can review that at the next meeting. And if we're lucky, Judy, do you think we would be able to find out on Commissioner Byrd's question on the ambulance territories by that time?
Yes, I would have time to do that.
Okay, and if it turns out we need legislation, then we'll get it on the list. Okay, sounds like everybody's on board with that. Terrific.
Best of luck.
This is Michael Smith. I just want to present, you do have an alternative of just doing an informal type letter. You could actually put all of this into the form of a resolution and forward that to the individuals that you're talking about, but it's really sort of a matter of style.
Mm-hmm. Anyone see a need for doing a resolution?
No, I think a letter is more personal and would be a more direct communication to the people we're trying to reach. Myself.
I tend to agree. The resolution looks like kind of a sometimes formal administrative thing that sometimes people pass over. They're so used to thinking of resolutions as not necessarily having a lot of weight. At least in the legislature, that's how they think about them. Okay, so with that, I think we're ready to move on to public comment.
Nobody signed up for public comment, Mr. Chair.
Okay, communications with Chief of Staff.
Thank you, Mr. Chairman. Commissioners, we had a division director meeting yesterday, and I'm happy to report everybody appears to be safe and well across the board and throughout the entire agency, even though the COVID cases seems to be rising throughout the entire state. It sounds like our agency staff have done well in avoiding any contact and have kept themselves safe and well. So glad to hear that. To no surprise to anybody, we only have one more open meeting this calendar year, and that's next week with the additional December 11th meeting. So we'll be getting together at least 2 more occasions before the end of the year. I also am happy to report that I think the Legislative Finance Committee presentation went well and short. Typically, we are in receipt of at least 8 different members, anywhere from 5 to 8 different members asking difficult questions of our agency, of our budget, of just issues and concerns that each of them have. But I think the quietness amongst the members this year probably shows that they realize the PRC is in need of support, financially, with the transition of the fire marshal's office and the supplemental funding that we've requested, now with the need of a private office. And so I've heard that it sounds like we get some legislative committee support. I'm hoping we are going to be getting some executive support during the legislature for our FY22 operating budget. My only other announcement that I'd like to make is I am having the Chief of Staff's office, along with a couple of others, Tina from Pipeline and Renee from HR, taking the lead and I guess asking and the agency if we would like to help needy families during a time like this. So be looking out for an email on how we can contribute. In the past, we've contacted CYFD and have identified a few families, and by donations from the PRC staff themselves, supported them during this season, especially during these troubling times of dealing with the COVID pandemic. So that's just an announcement. You'll get an email from the Chief of Staff's office forthcoming in the very near future, especially with the holiday season around the corner. Other than that, I believe we've touched on everything else. Mr. Chairman, I'll stand for questions.
Any questions from commissioners? Okay, communications with commissioners.
Mr. Chair?
Yes, Commissioner Espinosa.
What I didn't realize, I failed to mention earlier that when we had the Windstream case on the agenda, I just wanted to send out a big thank you to Frank Quintana and Espanola, who has been taking care of numerous complaints that I've received recently, and I just send everybody to him and he responds quickly. And so given the case on the agenda today, I meant to thank him publicly, because I'm not sure if his boss was listening to the meeting, but it's helpful. It's been very, very helpful because, the rural areas in northern New Mexico extend way up into those areas, and they not only are hurting for better broadband, but, the lack of services that's happening now with the storms and the COVID and everything. So I just felt it was important to thank these folks for responding to our needs and probably all the districts. And also, Ryan helps with consumer complaints. Of course, my assistant Kathy, I want to thank her too for connecting with these folks during this COVID time, and thank all the staff for their help and trying to work from home. And again, sometimes I have to make calls, but I want to thank, the folks at P&M, Mark Fenton, for being responsive, and Becky Carter out at New Mexico Gas. So it's really important to me to do this. And so I just want to send a public thank you. And thank you, Mr. Chair.
Thank you, Commissioner. Other commissioner comments?
Mr. Chairman, I just wanted to make a comment that it looks like we might have skipped over communications with General Counsel. Not sure if Mike has anything, but thought I'd give him the opportunity at least.
I think I've done that 2 times in a row now.
Maybe we could just remove it from the agenda in its entirety. No, I'm just kidding.
I don't know what to say here. Michael, I apologize.
No offense taken. I figured it was intentional, but no, I don't have anything. As you know, most when I have anything to discuss with you, I discuss it with the commissioners individually. So.
Okay. Terrific.
That means goodbye. Now you can go
think we
tend to
can
your
adjourn.
business, Steve.
Thanks to everyone for hanging in. Covered a lot today. Good work.